which are right now, which are prevailing at this moment, considering the completion of the CIRP of the corporate debtor, and now just in order to have the benefit of the haircut, which they have accepted initially, and in order to enforce the security in form of personal guarantee, which is available with the secured creditor, nowadays the applications are in numbers under section 94 and under section 95. Unfortunately, section 94 is being taken equivalent to as if the application is made by a corporate person under section 10, and they face tremendous trouble in reaching out to the boundaries of the admission of that application. But yes, you can see in any bench across India, section 95 applications are in flow these days. Now we will be dealing into this aspects. As far as this session is concerned, I would like to have the classification of the session into three parts. Initially, I would like to deal with the notification of 15th November 2019 and its impact on the code, wherein the applicability was also extended to the personal guarantor, which was challenged before the Honorable Supreme Court. And that was the case wherein Lalit Kumar Jain case, which has made the things very clear that the constitutional validity of the 15th November 2019 notification was upheld by the Supreme Court. And thereafter, the constitutional validity of section 95 to section 100, which was challenged before the Honorable Supreme Court, and Supreme Court has again made it clear that no right of the personal guarantor is prejudicially affected, and the role of RP during the course of application under section 95 was clarified. The opportunity which is required to be given to the personal guarantor prior to the application of that section 9 application, that was clarified by the Honorable Supreme Court. So with regards to the challenge which was made under section 95 to section 100 and its constitutional validity, that was upheld by the Honorable Supreme Court. And thereafter, multiple issues which are being faced by the personal guarantor. Can a resolution plan of the corporate debtor can take up the provision of the personal guarantor, whether the liability of the personal guarantor can be extinguished while approval of the resolution plan or not? So there are the judgments which are relied upon by the Honorable NCLET, or there are the settled law these days on the basis of the order which is passed by the NCLAT, reversing the order of the NCLT Indore bench in one of the matter. That is going to be the point of discussion. So I would like to have the brief introduction on the commencement or the notification of this provision of section 95 to section 100, and thereafter the procedural aspect of the insolvency resolution process for a corporate persons. So we will be dealing into that aspect first. On what basis the constitutionality of that notification was challenged? On what basis the provision of section 95 to 99 and even 100 was held unconstitutional initially by the writ petitioners, and the validity which was upheld by the Honorable Supreme Court? We will be going through the same before we touch upon the provisions of the insolvency resolution for a corporate persons, its procedure, its regulation, its rules. So that is going to be the second phase of discussion. But yes, I would like to first touch upon the initial aspect wherein the validity was initially challenged, later on upheld, and nowadays we can see the applications are being entertained by the Honorable Adjudicating Authority across India. So section 95 or 95 is one aspect, but apart from discussing 94 and 95, it is quite relevant to understand that for what reasons or on what fundamentals it was initially challenged, and later on the Supreme Court has made it clear that these are constitutional, or the power of the central government to implement or to notify the provision for a class of person among the person is constitutional. So we will be dealing into that aspect before we touch upon the provisions of the law and later on the rules and the regulations pertaining to section 94 onwards up to 121. But yes, it is important for us to first of all understand the Contract Act does not absolve. It is very clear that the liability of the personal guarantor shall coextensive. So unless the terms of the contract itself giving them a flexibility of getting a personal guarantor being relinquished upon approval of the resolution plan, that is altogether different. Otherwise, mere approval of the resolution plan will not settle or will not absolve or will not extinguish the liability of the personal guarantor. That is something which is very much cleared by the Honorable Supreme Court and by the virtue of the notification of the provisions of Section 94 onwards. Now, as far as the discussion is concerned, as I said, that we will be dealing into upon the, or will be dealing with the aspect, first of all, with regards to how the provisions was brought in initially, and later on we will be dealing into the provisions, and lastly we will be taking care of the regulation, and we'll see where it is practically creating the issues, or what are the stands being taken by the personal guarantor to avoid such applications on limitation aspect or on the aspect of invocation of the guarantee. So we will be dealing into what exactly the stands which are being taken by the personal guarantor to avoid initiation of insolvency, how the resolution plans, what we used to call in the company, here we used to call repayment plans, are being prepared, are being proposed before the creditors, and are being approved or disapproved by the creditors of the personal guarantor. I would like to share a screen in case if there is some lack of clarity in terms of its visibility, you may please inform. You may raise your question during the discussion, and we will be dealing into those aspects wherever the questions arise.
Vinit sir?
Yes, sir.
Has there any been like an order for discharge made so far? Any order?
Sir, you may please repeat your question.
Has there been any order like I'm discharging a personal guarantor?
Yes, there is an order. Initially, the order was not approved by the adjudicating authority, that was NCLT Indore bench it was. But the matter was challenged before the Honorable NCLAT, and NCLAT has made it very clear that if the resolution plan has provided relinquishments of the liability of the personal guarantor and consideration of the relinquishment of such guarantee, and if it is approved by the committee of creditors, in that circumstances, it is well falling within the wisdom of the COC to decide the resolution of the corporate debtor vis-a-vis the liability of the personal guarantor. So we will be dealing into that entire order of the NCLAT.
Sir, my name is Kashi Vishnathan Shivaraman.
It was in the case of Ujas Energy. We will be dealing into that. Yes, sir.
The recent amendment is going to say that personal guarantee cannot be released by a COC. The recent discussion paper by IBBI.
Discussion paper, but at this moment there is no amendment brought in by the.
It is not there.
MCA.
But one thing is, I do understand that. I do understand that, but there is a discussion paper which
Absolutely.
is going on
So
that.
And the views are being requested from
various stakeholders. Just for the information purpose, nothing
Correct.
more than that.
Absolutely, sir. That is correct. I'm not touching upon that part. The reason is the views may be right. The views may be different. And at this moment, we should wait till the amendment takes. So by that time, we will be touching only upon the aspect which are notified and which are available within the court.
Yeah, that is true, sir. Thank you.
We will be dealing into that. In case of time permits, we will be going into the discussion paper. We will touch upon what is the reason for coming out with this amendment or why the liability cannot be extinguished. So we will be dealing into that aspect subject to the permissibility of the time. But before that, as I said, the agenda will roll around this domain only. We will be going background. After going through the background, we will be going into the aspect of that Ujas Energy. That is the entire judgment of the NCLAT. We will be taking up the important aspects or important extract of the order. And we will be importantly discussing the provisions of the law which deals with section 94 to 121. We'll be going into the rules, we'll be going into the regulation. So in order to cover up the entire thing, if the time will permit, I will surely touch upon the aspect of what is the proposal of the bankruptcy committee in this regards, or what the discussion paper is all about, and what the intent of coming up with that discussion paper.
Fine, sir. Thank you.
Thank you, sir. Is the screen visible?
Yes, it is.
So I'm just going to the background of the things, and that is going to help us out in order to understand what section 94 and onwards are about. So we are not going to miss upon the most important aspect of the discussion, and that is the provisions of the act itself or provisions of the code itself. But let us see how that was notified, why it was notified, what are the hurdles before its notification, during its notification, before its implementation. That is going to be taken care of. And just in order to go into that journey, I'm just sharing the screen with you so that we can we can touch upon this aspect first. So as far as the genesis of the IRP of the personal guarantor, that is all about insolvency resolution process and not interim resolution professional here. Prior to the introduction of the code, the insolvency resolution of the individual was governed by the Presidency Towns Insolvency Act and Provincial Towns Insolvency, which was then repealed from 19th of August 2016 by the virtue of 243. But now here it comes the important aspect. That was an amendment. The Amendment Act 8 of 2018 amended Section 2 clause E, and that deals with to whom this code is applicable, and made the provisions of the code applicable to the personal guarantor of the corporate debtor. The unamended Section 2 clause E of the code, which made the provisions of the code initially applicable to the partnership firm and individual, was further it was classified into this three category, namely, yes, part 3 of the code is applicable to the partnership firm and the proprietorship firm, but which is not notified yet unless and until this partnership firms or the proprietorship firms are the guarantor. Yes, part 3 of the code of this IBC code is applicable to the individual also. But yes, apart from this, one subcategory was created out of the completion of the CIRP, and that is a personal guarantee to the corporate debtor, and that is Section 2 clause E. So this is something which was brought in. So the classification for the applicability of part 3 of the code into this division of individual, here it is applicable to the individual, it is applicable to the partnership firm or the proprietorship concern, but apart from that, it will be applicable to this class of individual who are the personal guarantee to the corporate debtor. And yes, Section 60 is very clear as far as the jurisdiction to initiate insolvency and to take care of the insolvency resolution process, or in case of unsuccessful completion of the insolvency resolution process, then in that case the bankruptcy procedure will also be undertaken pursuant to this part only, and that will be again governed by the honorable NCLT through the or by in the capacity of the adjudicating authority. For that, again, specific provisions and specific regulations are prescribed in exercise of the power conferred under subsection 1 clause 3 of the code, and there is a power of the central government to notify the provisions of the code. While notification dated 15th of November 2019, for the time being, I would like to share that notification. Now, this is that notification. Is this visible?
Yes.
So this was that notification which was challenged before the Honorable Supreme Court. Here it is. And you see the content, following provisions of the said code only insofar as related to the personal guarantee to the corporate debtor, meaning thereby it has made it very clear that as far as the notification is concerned, or as far as the applicability of part 3 of the code is concerned, by the way of this notification, it has been made effective, or the following provisions of this code shall come into force, and that is Section 2 clause E, which deals with the personal guarantor, what we were reading. Section 78, which deals with certain definitions. This is important, 94 to 186, for which today's session is divided. Dealing with the insolvency on the former part will be taken care of by me. The other learned faculty is going to take care of the bankruptcy part. But yes, we will be very well dealing into Section 94 and onwards up to 121, and that is going to deal with the insolvency resolution. So that was the notification of 15th November, which was challenged before the Honorable Supreme Court. Coming back to our original discussion, So that was a notification I was talking about. In exercise of the power conferred under subsection 3 of section 1 of the code, wide notification dated 15th of November 2019 by MCA, part 3 of the code relating to insolvency and bankruptcy of individual and partnership firm insofar as applicable to the personal guarantee to the CD, including impugned provisions, were notified. So basically, it was very clear that this particular part 3 of the code relating to insolvency resolution and bankruptcy of an individual and firm shall be applicable only to those individuals who are the personal guarantor to the corporate debtor and not to every other individual. And for them, the adjudicating authority is going to be the NCLT and not DRT. The validity of the said notification was challenged before the Honorable Supreme Court in case of Lalit Kumar Jain versus Union of India. So this thing has made it clear that it is well within the power of government to make a provision effective or enacted for a class of person within a class itself, on the grounds that inter alia the central government, while issuing a notification, has acted in excess of the power. So that was a challenge conferred under section 1 subsection 3, which empower government to notify the provisions of the code in part. It was contended that the power conferred upon the government under section 1 subsection 3 of the code could not have been resorted to in a manner so as to only extend the provision of part 3 selectively in relation to the personal guarantor. So that was a power of the government which was challenged, because the government has enacted part 3 only to the subcategory of the person among a class. So it was made applicable to a class of the stakeholder, or it was made applicable to a class of the person within a class itself. So out of an individual, there was a subcategory which was created, that is a personal guarantor to the corporate debtor.
Vinit ji, good morning.
Very good morning, sir.
See, it was notified in November 2019. Now,
Yes, sir.
So 5 years is going to be completed. Now, what is the chances of notification of other like individuals and firm?
Sir, initially what I can say, RP these days are facing a teething problem, because to initiate a process of insolvency against a person who majority of the people are basically the ex-promoter and ex-director of the corporate debtor, whose whereabouts and the personal informations are totally wiped out. With regards to section 19.2, what we used to study, that deals with the non-cooperation from the corporate debtor, here every second RP is facing a non-cooperation, because for a company there are multiple agencies from where you can generate a data. There are the statutory auditor from where you can get a data. There is a regulator. There is the registering authority like registrar of companies from where you can get the information. And there are the income tax authorities from where you can get certain information. But with regards to insolvency of a person, and to identify his creditor other than the financial institution is quite difficult in absence of any cooperation. And we are facing the trouble these days that no individuals are available to give the information. Rather, giving information, the people where's about is not available. So basically, just in order to first of all fight out with that initial teething problem, probably after going through that phase, part 3 may be notified for all the individuals and firms. So that is what I believe, that at this moment, to make it applicable for individual and partnership firms and the proprietorship firms who are not the guarantor, it will open a floodgate without matching up with the objective of the code, that is of resolution or bankruptcy, sir.
Because government has not anticipated all these things while repealing this Presidency Town Provincial Insolvency Act.
Absolutely, sir.
Both acts have been repealed. Now individual having no remedy to declare as a bankrupt. So,
and absolutely, sir, because this is what even
yesterday, I'm sorry, yesterday one client came to my office. He wanted to declare him as a bankrupt because he was not able to pay his loan and other things. I said it is still pending. So I thought I will discuss today.
And the second problem is, when you see section 94 applications which are being made before the tribunal, even by a personal guarantor, are not having so smooth admissions.
Correct.
Every section 94 applications are not being taken positively, and every anticipation of section 94 applications are akin to that they are here for getting the benefit of interim moratorium. So what section 10 is facing, the same problem is being faced under section 94 also.
And sir, moreover, the threshold limit is also one of the.
Yes, sir.
I said, like, the threshold limit of getting this admission.
Yes, sir.
Is also having problems, like, because see that amount is so small that every in today's economic scenario, this is just a peanut.
Absolutely right, sir. An application fees is more than that threshold limit.
Yes. There's another rule.
Absolutely, sir. So that is what
Sir,
I was.
Sir, do you foresee this threshold limit to be updated?
Absolutely, that is going to be altered. Right now, section 94, 95 and onwards up to 121. If I talk about the insolvency resolution, that is only confined to the personal guarantor, where the question of threshold limit does not even arise. Are you getting my point? But
Okay.
the moment part 3 will be notified for individuals and partnership firm, of course, there will be a round shape change in the entire rules and regulation. That is for sure.
Great.
Yes, sir. So we should proceed. As far as this Lalit Kumar Jain, we will see what was the question of law which was tabled before the Honorable Supreme Court. This is the point of deliberation, that was a point of arguments, that was a point of quarrel. Lalit Kumar Jain versus Union of India, and it is May 21, 2021. I'm talking about the phase when it was brought in, and after bringing it in, there was a challenge to the provision, or there was a challenge to the notification of only part 3 of the code. So issue in the Lalit Kumar Jain versus Union of India, the first issue was the central government's power. Is the MCA notification 15th of November 19 lawful and within the scope of the government power and authority? So it was challenged that whether the central government can create a category of class within a class itself to make this particular part 3 of the code applicable. Second one was, does sanctions personal so this is one of the important aspect. Corporate CD's personal guarantor, and that is what we are going to take care of in case of this Ujas Energy judgment. The protracted saga of the treatment of the personal guarantor under the IBC seems to have been finally put to rest by Honorable Supreme Court in case of this judgment. The inception of this tale was notification issued by the MCA on 15 November 19. That was an impugned or notification which brought into force part 3 of the code, dealt with the insolvency of individual only so far as it relates to the personal guarantor to the CD, as it targeted the promoter of the biggest Indian company undergoing CIRP. Notification led to stringent challenges as to constitutionality before high courts. Finally, on October 29, 2020, the Supreme Court has stayed the High Court from admitting or hearing any or all the writ petitions challenge the impugned notification, and that's why all those writ petitions have been transferred to the Supreme Court. Major ground of challenge against the impugned notification was that the central government did not have power to bring into force selected part of the code, and in turn, a creation of subcategory of an individual being the personal guarantor. This contention was premised on the claim that the power under subsection 3 of section 1 to bring the provision into force was only a function of conditional legislation, where the action undertaken through the impugned notification was inherently legislative in nature. So that was basically the outcome. Court analyzed the number of precedent to determine the scope of delegated legislation and conditional legislation, and it finally held that where the power granted to the executive wing was limited to determine when a particular provision must be brought into force and allowed making of a peripheral modification to effectively administer such law in a particular circumstances while keeping intact the inbuilt policy, essence and substance of the legislation itself, it was acting well within its power. So basically, the first question that whether this power which is conferred upon the government to notify the particular provisions of the code to a particular category of individual is valid or not. And it was very much made it clear that to make peripheral modification to effectively administer such law in a particular circumstances while keeping intact the inbuilt policy, essence and substance of the legislation itself. It has well acted within its power, and that is what I was addressing to Mr. Jain's query, that when it is anticipated that part 3 will be notified for an individual and partnership firm, I said right now the government is also checking how to address the concern with regards to this subcategory of individual, those who have extended guarantee on behalf of the corporate debtor in favor of their creditor. After getting this implemented, there will be a time wherein the teething problem will be addressed. It will be come up before the government and it requires certain clarification. And thereafter, there will be a stage when part 3 will be in a position to get it notified or amended for the sake of individual and partnership firms. The provisions of the code were brought in force in a phased manner from the very start of the implementation, which empowered government to decide when a particular provision would be made effective. As the beginning, it was important to set up the foundation pillar, such as regulatory body, related professional agencies required for functioning of the code, and thereafter the provision pertaining to operationalization of the code with respect to entity such as company incorporated under the Companies Act or other legislation and LLP were brought into force. The phased implementation of the code was a deliberate decision designed to fulfill the objective underlying of the code. So this is what the Supreme Court has made it very clear. Section 2 of the code lays down the list of entities that a code extend to, and the erstwhile unamended Section 2 of the code did not differentiate between the subcategory of individual. Personal guarantor to the corporate debtor, partner of the firms, and other individual were all grouped together under the erstwhile unamended 2E. However, erstwhile to Section 60 of the code contemplated. Now, this Section 60 is very important, which we are going to take care of, that who is going to be the adjudicating authority in case of this corporate guarantors and in case of the personal guarantor. So that is going to be taken care of. However, erstwhile Section 60 of the code contemplated that the adjudicating authority for personal guarantor was to NCLT, whereas for all the other individual, it is going to be DRT. Therefore, there existed a very clear inconsistency in the code with regards to treatment of personal guarantor vis-a-vis other individual. And the inconsistency was sought to be remedied through Insolvency Code, that is 2018 amendment. 2018 amendment, as I said, subcategory of individual into 3 categories, that is an individual, partnership firm, and the proprietorship firm. And the most important aspect which we are talking about is the personal guarantor. This was a calculated move following the recommendation of the report of working group of the individual insolvency, emphasizing the intrinsic relationship between the personal guarantor and the corporate debtor, and how the insolvency resolution process of the corporate debtor would be in a way incomplete without bringing the personal guarantor under the scope of the same. And that is the most important aspect, because once a plan is approved for a corporate debtor, the second empower or the second power or the second right or the remedy available with those creditors, those who have accepted some haircuts, is to invoke the guarantee. And suppose if they are invoking the guarantee, you cannot delay or you cannot wait for part 3 to be notified for all the individual to get the issue resolved, that in what manner the personal guarantor will be held liable for part of the liability which is not discharged or which cannot be settled through resolution plan. 2018 amendment also altered Section 60 in that insolvency and bankruptcy process relating to liquidation and bankruptcy of 3 categories, that is corporate debtors, corporate guarantors, and the corporate and the personal guarantor of the corporate debtor. So it has brought in within the ambit of the NCLT to be the adjudicating authority for all 3 category of person. It's not only the corporate debtor, but also the corporate guarantor and the personal guarantor of the corporate debtor. 2018 amendment, as far as it has inserted clause E of Section 2 and Section 260 subsection 2 to streamline the resolution process, is sought to bring together all the stakeholders under the same forum and aid the creditor to consider the holistic picture so as the nature of the asset available either during the corporate debtor insolvency process or even later, and to facilitate the creditor in framing realistic plan keeping in mind the prospect of realizing some part of the creditor dues from the personal guarantor.
Vinit
So
ji,
that was something. Yes, sir.
sorry for interruption. If
Please tell, sir.
proprietor or partnership firm gives guarantee to the corporate debtor, whether such proprietorship firm or the partnership firm will be treated as a personal guarantor?
Why not, sir?
If it is
They
registered
will be
firm,
falling within this domain only.
registered firm, partnership
Absolutely, yes, sir.
will be treated as personal guarantor.
Whosoever it is. See, if we are categorizing company extending guarantee on behalf of some other company, we are considering an individual extending guarantee on behalf of a corporate debtor for his creditor. Why not a partnership firm or a proprietorship firm? Proprietorship firm, I will not keep it separately from the individual. They are the individuals only.
Correct.
But suppose if a partnership firm has extended the guarantee,
Correct.
then individual partners will be held liable as a personal guarantor, and their resolution or their bankruptcy will be dealt in part 3 only.
Okay. Thank you.
So court therefore held that the impugned notification, I'm talking about 15th November notification of 2019, is not an instance of legislative exercise or amounting to impermissible and selective application of the provisions of the code. It took into account the phased implementation of the code since its inception, and that the intent of the legislature was never that the code should be made applicable to all the individuals, including guarantor at all once. So this was not the intent of the code. That is what the Supreme Court has made it clear. Conversely, there is a sufficient indication in code by section 2 clause E 5 subsection 22, 60, 179, indicating that personal guarantor through forming a part of the larger group of individuals were to be in view of the intrinsic connection with the CD dealt differently through same adjudicating process and by the same forum. So that is what the intent of the central government to notify only the part. This is the important aspect we all are aware of. Juxtaposition of the treatment of the personal guarantor under the code against the right of guarantor under the Indian Contract Act. The successful end of the process of CIRP is synonymous with the successful resolution plan, extinguishing the whole part. I request to kindly mute. I think this is not a question. So anyways, the secondary issue addressed in this judgment was the juxtaposition of the treatment of the personal guarantor under the code against the right of the guarantor under the Indian Contract Act. So here, if you see Indian Contract Act, there is a right of subrogation which we are going to take care of, but that is no remedy available with the personal guarantor. If you see from the prospect of the Indian Contract Act 1872, and that is the only reason I anticipate now guarantee will not be extended so easily on behalf of any body corporate. Company के behalf पे guarantors मिलने मुश्किल हो जाएंगे. That is something which I anticipated. Now guarantee deed will not be executed that casually, which used to be executed previously. The successful end of the resolution process of the corporate debtor is synonymous with the successful resolution plan, extinguishing the whole or part of the debt. Although the claim as against the corporate debtor stand extinguished, the same treatment is not rendered to the personal guarantor, as all avenue are open for the creditor to proceed against the personal guarantor. And this is something which is known to us, that the approval of the resolution plan will not settle the liability of the personal guarantor. 133 of the Indian Contract Act lays down, now this is again very important, that surety would stand discharged of the liability under the contract of guarantee if the terms of contract are varied without acquiescence of the said surety. Then only that person who is the guarantor should not be held or would not be held liable. I'm repeating again for the sake of requirement. 133 of the Contract Act lays down that the surety would stand discharged of the liability under the contract of guarantee if the term of contract are varied without acquiescence of the said surety. And here there is a clarity brought in by the Honorable Court. However, court relied on its pronouncement in SBI versus Ramakrishnan, where it is observed that the language of section 31 of the code is clear that the approved plan binding on the guarantor. The court rightly held that the approval of the plan would not ipso facto discharge a guarantor to their liability under the contract of guarantee, as extinguishment of the debt of the guarantor, the corporate debtor under the code was a result of involuntary process. Of course, so that is the most important aspect which is taken care of during this judgment of SBI versus V. Ramakrishnan, that court has rightly held that the approval of the plan would not ipso facto discharge a guarantor of their liability under the contract of guarantee.
Yeah, because lack of privity.
Absolutely. But here it is, the extinguishment of debt of the corporate debtor under the code was a result of involuntary process. It was an action initiated against them for initiation of CIRP. That is by operation of law or due to liquidation or insolvency proceeding, and same could not absolve the surety of their liability which arise out of independent contract. So here section 133, why it is not applicable, that is what addressed by the Honorable Court. Finally, the Supreme Court has ruled that the impugned notification is legal, not ultra vires. The writ petition, transferred cases and transfer petition were dismissed. Legal provision dealt in Lalit Kumar Jain. So that is what we have dealt into. I'm not going to again touch it upon. Now, this is in case of Rajendra K. Bhuta versus Maharashtra Housing and Area Development Authority. The court stated that under section 60 subsection 2, the insolvency process of three category, which are the corporate debtor, the corporate guarantor and the personal guarantor, have to be applied in such a manner that the liquidation resolution applies to the corporate guarantor or bankruptcy process applied to the personal guarantor who cannot be subject to liquidation, meaning thereby that was the overall intent. Analysis, yes, this is what we have seen now. This is the Dilip Jivrajka versus Union, wherein the provisions of section 95 to 100 was challenged subsequently, wherein the Reliance Communication and Anil Ambani was also one of the writ petitioner. 95 and onwards up to section 100 was challenged before the Supreme Court. The constitutional validity of the provisions pertaining to the personal guarantor in part 3 of the Insolvency and Bankruptcy Code were recently challenged in series of 384 writ petition filed under Article 32 of the Constitution of India. The validity of section 95 to 100 of the code was challenged inter alia on the grounds that they are volatile of the principle of natural justice, on the ground that personal guarantor was allegedly condemned unheard, unfettered power including adjudicating power were vested with the RP. On 9th of November 23, while a common judgment delivered in case of Dilip B. Jivrajka versus Union of India, the Supreme Court upheld the constitutional validity of the impugned provisions of the court and dismissed the writ petition. So that was all in grounds of these three textures. One is, do the debtor and a personal guarantor have right to know the ground for accepting or rejecting the insolvency application? So initially it was notification of 15th November which was challenged. When the constitutional validity of that 15th November 2019 notification was upheld, thereafter the writ petition was moved under Article 32 of the Constitution before the Honorable Court on three grounds. That whether the debtor and a personal guarantor have right to know the grounds of accepting or rejecting insolvency application under 95, and things are now very clear that any 95 application is required to be served upon the personal guarantor. Not only that, the report of the RP on the application, recommendation of its acceptance and rejection is also required to be served upon the personal guarantor. So things have been settled. Does an order of interim moratorium by RP amounts to an arbitrary exercise of the power? So that was the second point of challenge. Third one, does the submission of the RP's report under 99, very important, without providing a copy to the debtor and personal guarantor, violate the principle of natural justice? And I'm sharing one circular in this connection. I'll be sharing in due course. It is not opening, but yes, there is a circular wherein it has made it very clear that this is mandatory upon the resolution professional to serve the copy of section 99 to the personal guarantor as well as to the corporate debtor while making an application under section 99. So that is what the point of querel before the Honorable Supreme Court, on the basis of which the writ petitions were moved under Article 32 of the Constitution, challenging the constitutional validity of section 95 onwards up to section 100. The impact of the personal guarantee in relation to the corporate debtor undergoing insolvency resolution process under IBC has raised interesting legal issues. A personal guarantee refers to a promise made by an individual to assume responsibility of repayment of a debt in event the corporate debtor fails to fulfill its obligation to a creditor. Recent pronouncement of Supreme Court in Surendra B. Jivrajka versus Omkara Asset Reconstruction Private Limited has settled the ambiguity surrounding the liability of the personal guarantor. Nevertheless, certain issues remain unaddressed. Following the IBC Second Amendment, the notification dated 15 November of personal guarantors are directly subject to insolvency proceedings without requirement of creditor primarily initiating the insolvency process against the corporate debtor. So it is again made it clear that it is not mandatory upon the creditor to first initiate CIRP. The only prerequisite is the guarantee should have been invoked and there has to be default in full or in part by the personal guarantor. The Supreme Court recently clarified the constitutionality of these provisions along with the extent of the liability attributable to a personal guarantor in the legislation. The judgment is critical since it grants higher leverage to the creditor of the corporate debtor to retrieve the outstanding amount that was not collected, and that was the intent of the code. It was the creditor-centric code. I hope it's visible.
Vinitji, I would say that you have explained very well about the background of all these things. Now, can I request that because the limitation of time, you can straightforward come to the enacted this regulations and other.
Absolutely, we will be dealing into, and that is something which is all going on within my mind, that how to cover that up.
Yeah.
But there is very important aspect which is coming up, and right of subrogation, I would like to take it up.
Please.
So that is going to follow with this slide only, or this thing only. We will be dealing into that aspect, sir. Liability of the personal guarantor, that is the applicability of coextensiveness and ipso facto discharge. There is some point of discussion with regards to this slide, and that's why I'm still connected with this. The liability of the personal guarantor is coextensive with that of the corporate debtor, is expressly provided under 128. Personal guarantor's liability is established through an independent contract, and the contractual terms dictate the nature and magnitude of liability. Hence, the creditor may initiate the legal proceeding against both the debtor and the guarantor simultaneously, or they may decide to proceed in any other preferred sequence. Proceedings against a personal guarantor may be either to recover the amount or the remaining amount. The conclusion can be drawn that once the plan is accepted by the COC, the liability of the corporate debtor comes to an end, thereby ultimately discharging the personal guarantor of its liability as well. The rationale as analyzed from the provisions of the ICA does not hold valid owing to various rulings of the High Court, and the liability of the personal guarantor continues even after the corporate debtor is discharged from its liability. Now, what I wanted to establish out of this discussion is, I'm just coming to the most crucial aspect, and that is the unaddressed issue. Though it was made it clear that 95 to section 100 is constitutionally valid, but now this is most important aspect. The code introduced a paradox promising enhanced recovery for creditor but imposing notable challenges on those standing as a guarantor. One pressing issue is the potential for multiple and concurrent insolvency proceedings, because it happens a person is holding directorship in multiple company, and in all those multiple company, the person has extended a guarantee, and there is a further possibility that all those companies may face insolvency process one or some other day. In that case, the clarity pertaining to the jurisdiction is unaddressed issue. That is one of the aspects. And I've seen in many of the cases, for example, Mr. A, who has extended a guarantee on behalf of a company in Ahmedabad in favor of a State Bank of India. And similar, Mr. A has also extended a guarantee on behalf of a company in Hyderabad in favor of the Standard Chartered Bank. So this jurisdictional issue is still a challenge for an RP and even for an adjudicating authority, because it is clearly stated in section 60 that jurisdiction is the jurisdiction of the NCLT, which is dealing into the insolvency resolution process of the company. But what in case if there are multiple company for which a person is standing as a personal guarantor, and all those companies are facing the heat of the initiation of CIRP? So these are certain unaddressed issue.
Correct, correct. It
I
has
believe one more unaddressed issue is pertaining to what we have under section 43 or 44, 45, 66, that everything is missing under this particular part 3. There is nothing like avoidable transaction or a preferential transaction, or there is nothing like a extraordinate credit transaction. And this is very important that such provisions of the code should also extend to the personal guarantor, because nowadays the personal guarantors are highly learned and they know how to divert the asset available with them. The code introduced a paradox, promising enhanced recoveries for the creditor, but imposing notable challenges on those standing as a guarantors. One pressing issue is the potential for multiple and concurrent insolvency proceeding. The coextensive liability of the debtor and the guarantor allow the creditor to initiate simultaneous insolvency action against both the parties. This raises a concern about the jurisdictional conflict and operational challenges for the NCLT. The example of a guarantor providing a guarantee for a company in different location, coupled with initiation of CIRP in different cities, further underscores the complexity. Subsection 2 of 60 of the code mandates filing of insolvency petition against a guarantor where CIRP of the borrower is underway, creating uncertainty regarding the precedence and formulation of repayment plan across multiple proceedings. So this is what I wanted to address before we actually go into the regulation. Another issue, and this is something which I feel the most important part, and another issue emerges in the form of creditor is double dipping, a practice allowing creditor to initiate simultaneous CIRP against both debtor and a guarantor. While NCLT expressed concern about double dipping, the coextensive liability of the guarantor and borrower, subsection 2 of 60 of the code permits concurrent proceeding against the parties. This potential for double dipping by creditor raises a question about fairness of the insolvency resolution process of personal guarantor. This further calls for the question of res sub judice. How is the code permitting concurrent proceeding when a proceeding on the same matter, same issue, same party is already submitted before the tribunal? So that is, in my view, is one of the concern.
Arm twisting weapons. This is like.
And on one side, while dealing with the applications, the tribunal used to mention in its order that this is not a recovery forum. Now, this double dipping indicates the recovery itself.
Correct, correct.
Because if the code is meant for the resolution of the corporate debtor, then ultimately the objective of the code should be an umbrella for individual also.
Correct. It's creating practice, pressure tactics.
So that is what I wanted to, sir, highlight out of this particular content. Otherwise, even I am more keen into dealing with the provisions first.
I appreciate your explanation. Excellent.
Sir,
yes, sir.
Sir, there are two things to it. One, with regard to multiple guarantees given to various companies situated in across the country. Is it not the address of the director which is to be taken up, and the NCLT has to address that issue over there? Is it
absolutely?
Not like that?
And I back your view, sir, because where a person is normally residing or a person is carrying on its business or its vocation, ultimately that is going to be the right jurisdiction from where you get the maximum creditors or the claims.
Yes,
absolutely. But this is my point, that this issue is not addressed in express way.
And second thing is with regard to double dipping, what you're talking about. It is, see, first of all, the financial creditors have never understood the process as a resolution process. Still, they consider like DRT or whatever you call it, recovery process only. In every forum, if you take it up, financial creditors does not say that I have come here to recover my money, not to resolute the company.
Correct.
This is what is, in open forum, they are saying this. Unless and until it is very strictly followed, it cannot be enforced. It should be followed properly in dictum, to be in exact word and precision. But normally it is not. Every financial creditor wants to do double dipping, one with the corporate guarantee which is being given, and another company bringing it under CARP process, so that the recovery process takes place. These are things which are to be addressed.
Absolutely, sir. And that is what I feel a difference when we hear the arguments of the learned advocates, or when we hear the outcome of any application under Section 9 and Section 7 quite differently. Under Section 9, the adjudicating authority, the honorable bench member, they emphasize again and again on the same statement that this is not a recovery mechanism, or this is not a recovery forum. But ultimately, every section application or under Section 7 is meant with a very single aim. Because if you are processing against the corporate debtor, and simultaneously if you are moving an application against the director in the capacity of the personal guarantor, they have extended a guarantee. This clearly indicates that the objective of the code is not within the purpose of the application. So I think that there has to be some set of rule which is required to be framed in, more particularly in the case wherein the erstwhile management, the promoter in a MSME category, they are coming up with a plan. Because when they propose a plan for a corporate debtor before the COC, ultimate intention of placing such plan is to get their control back. Their intent is to run the corporate debtor after having a resolution plan accepted by the COC. Now, on the one side, if the COC is accepting my plan as a person, as a promoter of the corporate debtor, but contrary, after accepting the plan, if he will be going against me, drag me before the court of law for the remaining amount, then in that case, the intent of the plan being approved by the COC is not going to match its purpose.
That is very true.
Suppose if me and you are on the board of the company, extend a guarantee, proposing a resolution plan with an intent to rebuild the corporate debtor, proposing certain haircut accepted by the same COC with an intent. If the COC is accepting our plan, COC is accepting the fact that yes, we will not be in a position to pay anything beyond what we are proposing. After accepting, you are promising a corporate debtor, or you are supporting a corporate debtor to come out of the insolvency. But immediately after the approval of the plan, if you will be kicking the company's guarantor, the same person, those who have proposed a plan, your intent of accepting the plan comes to an end.
That is very true.
So that can only be resolved through some set of rules, set of regulations, which at present are very ambiguous.
That's the order of the day.
Can you repeat what you said last?
Sir, what I said last is, Mr. Himanshu, if me and you are the directors of the company, we both are proposing a resolution plan as an MSME promoter. The resolution plan is accepted by the consortium bankers. It is accepted by the committee of creditor. If they are accepting a resolution plan proposed by me, in the plan I am mentioning that Mr. Himanshu and Mr. Vinit will be continuing as a director. I have mentioned that Mr. Himanshu and Vinit are going to be the shareholder. This is how we are going to take care of the manufacturing part or production part. Every aspect we have mentioned in the resolution plan. Moreover, we have also proposed an amount to be payable to my creditor. The same creditors, they have accepted the plan proposed by the promoter. Acceptance of the plan of the promoter, meaning is they are assisting the corporate debtor in its revival process. But after accepting the plan proposed by Mr. Vinit and Himanshu, in the capacity of the promoter of the corporate debtor, if the same class of the creditor, if the same bench of the financial creditor will be dragging me before the same NCLT, invoking personal guarantee, putting me into difficulty stage of the insolvency, will the purpose of proposing a plan and approval of the plan will serve its purpose or not? That is my question. On the one side, COCs are accepting the plan. On the other side, they COC members are dragging the same resolution applicant. Generally, in case of the ex-promoter, in the capacity of MSME promoter, they are dragging them into difficult situation of insolvency and bankruptcy. Then overall rationale or the intent or the implication or the, you can say, implementation of the plan is not going to take place or will not be able to successfully take place if this is going to be the stand of the COC or if this is going to be the stand of the financial creditor after accepting the plan of such promoter. So that is what my point was.
Sir. So in such cases, suppose MSME promoter is giving the plan, then he should include there in plan extinguishment of personal guarantee.
Absolutely, and they can very well, because that is what we are going to take care of in Ujas Energy judgment. This can be very well proposed, though there is some, right now, there is no clarity with regards to whether they cannot. So right now there is a guidance note or there is some recommendation which is invited from the stakeholder. But at this moment, I must say that in the resolution plan, a COC can very well dealt with the extinguishment of the liability of the personal guarantor, especially in a case where a resolution applicant is also proposing some consideration in lieu of that extinguishment of the personal guarantee. Personal guarantee can be dealt up in a resolution plan as on date.
Okay, thank you, sir.
And the most important aspect leading to which I was mentioning that now it will be very difficult for companies to get the guarantors. Getting guarantors was very easy initially because at that time, the guarantors have not felt the heat of the committee of creditors or the financial creditors. But now extending guarantee, you are not getting any consideration. And I was talking about the right of subrogation, which is completely missing. I'm coming to that part. Lastly, the extinguishment of the guarantor's right of subrogation under the code stands out as a significant issue which the court have failed to address so far. See, if I'm giving a guarantee on behalf of the corporate debtor in favor of the corporate debtor's creditor, where will my right goes? Because it is very clear law that suppose if the corporate debtor fails to make the repayment, then in that case, the guarantee will be invoked. Now, in case if the guarantee will be invoked, and if I discharge the liability of the corporate debtor, will I be in a position to get it recovered from the corporate debtor? No. This is the most important aspect which I feel requires some kind of address and attention. The extinguishment of the guarantor's right of subrogation under the code stands out as a significant issue which the court have failed to address. Traditionally, the guarantor possesses the right to step into the shoes of creditor. The guarantor possesses right to step into the shoes of creditor, recovering money paid on behalf of the principal debtor. However, the court denies guarantor this right, emphasizing the pro-creditor nature of insolvency regime. Denial of the right of subrogation will only hinder the personal guarantor from extending guarantee, owing to extremist nature of the court towards the personal guarantor. Now, here I would like to have your views on it. Now, this is the most important issue which I, as a student of law, can feel that this is an issue leading to which I don't think so that now it will be very, or any director or the family member of the director will be so happy and so comfortable to extend a guarantee on behalf of their own family company. Here I would like to have your view, sir. Any of the participant.
The issue should be taken up on two fronts. One,
Absolutely.
right of segregation should be allowed if you are making the personal guarantor to be liable to be paid. Both things should run simultaneously, not separately. You are not allowing the personal guarantor to recover the money what on behalf of the corporate debtor he has paid. So right of subrogation, and if the personal guarantor is being pulled up, then it should be allowed. That is my opinion, sir.
Absolutely. The reason is, sir, now I'm coming to this aspect again. Now, suppose if we have extended a personal guarantee, this personal guarantee was extended on behalf of the CD. CD has already committed a default in payment to its creditor. CD probably must be in CIRP or must be in liquidation at this stage. There is nothing left out in the CD to recover. I know that if CD fails to make payment, the creditor is going to hit on me. Creditor, after invoking a guarantee, will come to me for recovery. Now, even though in this case I am in a position to make the repayment, in this circumstances, even though I will be in a position of repayment, but my next question would be, if I repay my right as a guarantor, can I able to invoke my right as a guarantor? If no, because I have to invoke my right as a guarantor from the corporate debtor. Corporate debtor probably is in liquidation. Section 53 will not even place me in that topmost position. So in that case, if I don't have any hope of getting anything recovered, then for what reason I extend guarantee? And if I have already extended the guarantee, I will be having all the reasons to disseminate my asset, transfer my asset, gift my asset, to actually put my hands up for insolvency or for bankruptcy. And there will be no recourse available with me other than accepting and admitting my insolvency condition.
Correct. The right of subrogation will be defeated.
Absolutely. So that is my concern with regards to the entire topic. I can very well deal with the provisions of the code, but the provisions of the code are unaddressed in this aspects.
One small point which comes to my mind is, once
Yes.
the payment is being made by a shareholder or whatever, director or something like that, does he not become an unsecured creditor to the company?
Absolutely, yes.
Then it should be addressed in Section 53.
But now the point is, sir, what unsecured creditors are going to be, or what is left for the unsecured creditor to recover?
Nothing is there. Nothing is there.
Another point is, I have not filed my claim, so I am not even in the list of the stakeholder
COC.
consultation committee. When I will be in a position to claim, only in case when I have made the payment to the financial creditor upon invocation of guarantee. When I know that I am hopeless and there is nothing to get recovered out of the asset of the corporate debtor, and there is nothing left out for this unsecured financial creditor, then probably I will be the last person to make any payment to the banker, or probably it will be more easy for me to accept my insolvency rather than repayment.
Very true.
So what I believe is, after giving a personal guarantee, the moment company faces the wind of the insolvency, the moment company will face the wind of the insolvency, probably the personal guarantor would be the first person. The personal guarantors are going to be the first person who would like to transfer all their valuables or all their wealth, because they know that their insolvency is inevitable in this circumstances.
Whether in foreign countries also similar provisions are there?
I have not gone through, sir, because this code itself is making me more, you can say, troublesome to understand that how these issues are going to be addressed. And that was your initial question, that why the insolvency part 3 of the code is not made applicable to the individual, because individual are not so relevant is economic viewpoint. From the economy's, it is very relevant that such issues need to be addressed wherein the stake of the bank are concerned, or where the high stake of the other stakeholders are involved. And that is what I feel, that this is something, this issues require a clear. I just want to go into one more aspect in this case. Now, these days, insist.
Sir, you are not audible. I think there is some network issue at your end. Vinit ji, Anjali ji, are you there?
Doubt he is trying to log in again.
Okay, I think there is some network issue. His voice was some cracking sometime.
Yes, sir. He is logging again. He is logged out.
Okay, thank you.
Ajay sir, where do you practice, sir? As an advocate?
Delhi,
Delhi?
yeah.
Yeah, I have seen you somewhere. It's not very recollecting. Do you come to regularly to Delhi Supreme Court?
Sometimes, not always. Sometimes when matter listed.
Yeah.
My
Sometimes
chamber number is
I have seen you. Yeah.
218 with Mr. Ajay Veer Singh Jain. Chamber number.
Yeah, because I have seen somewhere in the corridors of the Supreme Court. That's why I remember I'm not collecting to you.
Yes. I also used to play badminton. I have participated in badminton tournament and then cricket tournament also. This time again we won this tournament at above 50.
Okay. But I have seen in only court corridors only, sir. I have seen only court corridors.
Okay.
Supreme Court corridors.
Okay.
Yeah.
Thank you.
Sir, I
It's
lost
okay.
the connection. There was
It's
one
okay.
technical issue. We failed to understand IBC as a whole, and it is quite difficult for us to understand the internet connectivity to a great extent. So this is our subject, and we failed to understand. This IT was never been our subject. So that is, I have failed to connect. I don't know. I tried multiple times, and finally, I was successful in getting connected. But I missed your very important discussion, which you must be having in between. If you can please share any of your case you were discussing, probably.
We just took advantage of just to exchange few words with
If you can please share with me your experience in this connection, I will be more fortunate to have this outcome of your matters.
Yes, so we were just discussing about yes, please, Ajay ji, please go ahead.
Section 9 application, and thereafter this we were also discussing that this double blow on the personal guarantor. It is just like in constitution there is also provisions that rules against double jeopardy.
Absolutely, sir.
So similar here, we are also seeing the same kind of things here.
I must say that, sir,
One person should not be punished. One person should not be punished twice for the same offense.
And Vinit ji, we also touched upon a bit of the terminologies being.
Sir, you are on mute, sir.
Yeah, so actually we discussed a bit about that solvency part of it.
Correct.
Many companies, those who are solvent and the opponent and the respondent are able to prove that, okay, we are a solvent company and that our case should not be admitted. And the petitioner has just come here and just window shopping for getting their money recovered.
Sir, everybody knows that the intent is ultimately to get something out of this pressure tactics. And this is probably the only application which take away the position, which takes away the chair, which takes away the role and your verchesva, I can say. Correct. And this is the right hit, or this is the only tool available with this creditor to get their desired result. So that is something which is known. And now the contrary view is, if you are solvent, then there should not be any harm in payment also. So meaning thereby, if you are solvent and having some issues with regards to payment, there is a dispute. And if there is a dispute, then this is not a forum. I've seen many of the matter, even though disputed matter, but still this are being adjudicated upon, still are being entertained by the honorable benches of NCLT.
Yes. In fact, in many cases, even though arbitration clauses are there, there is a dispute, still many NCLT admit the matter, and we are unnecessary, dragged into NCLT.
Because this is very clear code. You need to simply check debt and default. You are not supposed to go beyond it, and you are not supposed to go below that what was the reason leading to this default. So if there is a dispute, then this is not a forum wherein one can approach or one should be entertained anymore.
So then why, like, the recovery part of it, like, crops up every now and then while hearing a petition, sir?
Sir,
When we know that, okay, that...
Sir, the corporate debtor, once they have admitted the debt, they don't have any other thing to argue.
Yes.
If they have nothing to argue, they will surely pop up with this point that they are here for the recovery. And ultimately, my point is the same on the face of it, that if they are here for the recovery, and if this is a legitimate demand, then you should make the payment. And if this is not a legitimate demand, then showcase whether this illegitimacy was proved and was communicated by you. If it was not communicated by you prior to receipt of the demand notice, then make the payment and get this matter out of court. That means if you are making the payment, there is a possibility that the application will be withdrawn. But if there is no dispute and still you don't want to make the payment, then howsoever solvent you are, the application is inevitable, that it cannot be avoided, or the admission cannot be avoided in that case.
Vinitji, I have one small question.
Yes, sir.
Suppose if the person has a dispute, but it has not been surfaced or we cannot prove it, but the company is solvent, is it possible that the company they deposit the amount in the NCLT and then take up the matter in a civil court?
Sir, this can be a very, you can say this can be very smart move in order to avoid the litigation, in order to avoid the insolvency. This can be proposed that yes, it is a disputed one. We are giving this undertaking and there is no requirement of depositing any amount. Because if it is a case of pre-existing dispute, it should not be entertained. Suppose if it is a case of dispute, then in that case, very well the matter can be deferred by giving or by opting out with this proposal that yes, we will be ready to make the payment. Suppose if that matter will goes against us in the relevant court of law. So this can be done, why not? And that can show your legitimacy pertaining to the case. But make sure the dispute should not be, you can say, an afterthought. There has to be some clue of dispute. There has to be some smell of dispute. There has to be some substantial document to justify that dispute prior to your application or prior to the application of the creditor against you.
Because
and I must say
the same like, argument will be tested in other court also.
Absolutely, sir. Yes, sir. I was coming to this, or I was about to start one very relevant point, and that is, see, if I am the director, if I'm the director of the company, the bank is not going to left me over, and bank will insist me to sign the guarantee agreement. So guarantee deeds are going to be signed by me. Nowadays, the guarantee deeds are signed in a very casual approach. The reason is at the time of signing of the guarantee deed, the corporate debtor is only having a single thought of getting some disbursement as early as possible. Now, what I face a big trouble is, there are the occasions when directors resign. There are the occasions when directors are removed by the shareholders. I'm talking about a dispute which are very much related to the Companies Act. In the Companies Act, there is a provision of section 169 which empower the shareholders of the company to remove a director. There are the provisions under the Companies Act which talks about disqualification of director, and which talks about if a director gets disqualified, they have to vacate the office as a director of the company. In that case, now suppose if I resign the board of the company, or suppose if I have been removed out by the company shareholder, then I will be the first person to knock the door of the bank that kindly bring me out of that contingent liability of being a personal guarantor. That will be the first thing which I will be doing after getting myself stepping out from the board. Even though that resignation was a mutual one, or that was amicably decided that I will be stepping out from the board, or else it was not amicus, or it was not amicable, and it was the shareholder who initiated an action for my removal. But the first thing which I would like to do after stepping out from the board is to approach the bank in order to request bank for removal of my name from the personal guarantor. Because after I being out from the board, I don't have any control over the operations of the company.
So
If I'm not a member of the board, I don't have any control over the operations of the company. If I don't have any control over the operations of the company, I don't have any assurance whether the company will be able to fulfill its obligation from time to time with regards to repayment to bank. Now, suppose tomorrow if company makes any default with regards to payment to the creditor, a financial creditor, the financial creditor would like to invoke the guarantee. And while invoking the guarantee, I will also be considered as one of the person whose liability is to discharge on behalf of the company. In spite of I was having no role to play since years, in spite of I was having no control over the operations, in spite of I was having no control over the external and internal reasons leading to which that default take place. But this is the biggest problem which I'm facing, that the client is coming to us mentioning the fact that I resigned from the board, but I want to come out of that liability of being a personal guarantor. We are approaching bank, and bank are not entertaining such applications or requests unless and until the corporate debtors are giving some additional security or additional guarantee. Now, suppose if the shareholders have initiated an action for my removal, no company would like to make the bankers happy and to keep me out from guarantee. Now the companies are adamant they are not giving an extended guarantee. They are not giving an additional security, and bankers are not so comfortable in bringing me out from the personal guarantor. So this is one of the unaddressed issue which requires some clarity through amendment in the code or any other law. Because when a person is no longer servicing the company on the board, he will not be having any control. And when a person, there are the things which are beyond his control. For the things which are beyond his control, he should not be held liable for a situation which was not created by him or attributable through him.
Sir, is there any remedy available to such people?
That is the remedy which I'm seeking from the learned participants, because this is the kind of problem which I'm facing on a very regular basis.
I think guarantor should write in the guarantee deed itself that my guarantee or this guarantee will subsist so long as I am director of the company.
Right. Because
Many
he is
times.
signing irrevocable
Absolutely.
guarantee.
By mentioning the same in the guarantee deed, yes, I can be protect or I can protect myself. But if you see the majority of the guarantee deed, almost all the guarantee deeds are basically the authors of such guarantee deeds are the bankers only. They don't entertain and they don't feel so comfortable when I amend the guarantee deed.
Absolutely.
Generally, banker approach me only for the signature.
Particularly PSU, public sector bank, they are taking the same wording of British.
Absolutely. So when
Dotted
we will
line
be dealing
you have
into
to sign.
correct,
There
sir.
is nothing which is called, you are given the document for reading the document, personal guarantee document.
Even nobody
You are
is
just,
like to read. Once the money is coming, nobody is care to read. It is happening.
that is what I am saying. अंगूठा छापना है, अंगूठा छापना है, बस. कहाँ बोलो, मैं अंगूठा छाप देता हूँ, वहाँ बस.
जहाँ पेंसिल से क्रॉस कर रखा है, साइन वहीं पे करनी है.
Vinit, they are not even allowing you to put, fill up the form fully and then they ask you to sign. They simply say that you sign. It is the blank form, and everywhere they take your signature, nothing else.
Actually,
But sir,
absolutely any amendment, even a single word, this is nothing doing. You have to sign on dotted line.
And that is the point, sir, I was into, that now the issues are coming up before the stakeholders. Now the victims are many, and you will be in a difficulty. The company will face high difficulty in getting such guarantors, and that is what I believe is going to happen.
And Vinit sir, कहावत है ना, लेने वाले का हाथ हमेशा नीचे रहता है. So while signing that agreement, like you are always like you don't see here and there, you simply put your signature over there.
So this is the most troublesome situation, sir.
Yes.
Sir, I was willing to discuss this particular judgment with all of you. This is the Anclet judgment in case of SVA Family Trust versus Ujas Energy Limited. Now, this is where I would like to have with you that what was the case and how the resolution plan has tackled the issue of absolving or resolving the personal guarantor's contingent liability. And this particular NCLT Indore bench judgment was completely, you can say that Anclet has basically reversed the decision of the NCLT Indore bench. So let us go into the facts of the case. The Supreme Court judgment in Lalit Kumar Jain versus Union of India made clear that the resolution of the corporate debtor under the IBC does not automatically discharge the guarantor of the corporate debtor from liability. Resolution plan often state that while approval of the plan would extinguish the creditor's claim against the corporate debtor, it would not prevent creditor from pursuing their claim against the promoter and guarantor of the corporate debtor. A recent judgment of the NCLT, that is NCLET, considered the converse issue. Can resolution plan provide for release of personal guarantor when personal guarantor has not been subject to insolvency resolution process? Now, this is very important issue which we are going to deal as far as the discussion is concerned, that whether the resolution plan can provide for release of the personal guarantee when personal guarantor has not been subject to insolvency resolution process. SVA Family Trust versus Ujas Energy Limited. The resolution plan proposed by SVA Family Welfare Trust provided for total payment of approximately 74.8 crore to settle the creditor dues of the corporate debtor, out of which 23.8 crore was earmarked as consideration for release of the personal guarantee issued by the promoter of the corporate debtor. So it was the resolution applicant SVF Family Welfare Trust. The resolution amount was 74.8, out of which 23.8 amount was considered in order to release the personal guarantor, which was extended by the promoter of the CD. That plan was approved by 78.4% of the financial creditor. So COC has approved the resolution plan with more than 66% voting shares. But one of the financial creditor, and that was Bank of Baroda, objected to the plan, contending that the resolution plan of the CD could not take away the right of secured creditor to proceed against the personal guarantor. Prima facie sounds all right. The NCLT Indore bench also rejected. Now, it was the Indore bench, though not specified here. The NCLT Indore bench also rejected the plan on the grounds that plan could not provide for release of the personal guarantee. So basically, NCLT Indore bench has taken a view that you cannot take away the right of secured creditor to proceed against the personal guarantor. That was a view taken by the NCLT Indore bench. But NCLET has set aside the order of the NCLT Indore bench, stating the fact NCLT reversed the decision of the NCLT Indore bench, holding that it is well within the commercial wisdom of the COC to approve a plan that provided for release of the personal guarantee. NCLT acknowledged that there had been cases such as the Supreme Court decision in Lalit Kumar Jain, which made it clear that the resolution of the corporate debtor did not per se discharge the guarantor from liability. However, this judgment, very important para, however, this judgment does not imply that plan could not provide for release of personal guarantee. Iska jo कहना था, what they have stated out of it is, NCLET has made it very clear that Supreme Court decision in Lalit Kumar, though it has made it clear that the resolution of the CD will not per se discharge the PG, but that judgment has not made it very strong commentary that the plan could not provide for release of the personal guarantee. NCLT differentiated this case from its prior judgment in Nitin Chandrakant Nayak and Sanidhya Industries, wherein the tribunal had held that the plan could not consume the asset of the personal guarantor without recourse to the appropriate proceedings. Here, the asset of the personal guarantor is not in question. The resolution plan in Ujas Energy, NCLET pointed out, did not deal with the asset of the personal guarantor, but only provided for release of the guarantee that had been granted as a security for financial assistance provided to the corporate debtor. Finally, NCLET emphasized that the minutes of the COC clearly reflected that the release of the guarantee had been discussed at length, was a deliberate decision of the COC, given that COC had already applied its mind in agreeing to release of the personal guarantee in consideration for a specific payment. The NCLET found no reason to question the exercise of the commercial wisdom. COC is indeed granted significant discretion in exercising its commercial wisdom, a point that had been widely accepted by the court and tribunal, particularly after Supreme Court judgment in SR. It is also the case that IBC provides for a wide range of action that may be taken through plan, with section 31 of the IBC stating that plan are binding on stakeholder of the CD, including guarantor. However, the NCLAT judgment in Ujas Energy nevertheless raises a critical question of whether a plan can extinguish the right of creditor to proceed against the parties other than the CD. Now, this is the only reason right now it is open in a public domain to put the views of the stakeholder in this connection. Though the corporate insolvency resolution process, individual creditor give up their right to take the separate enforcement action and are bound by the decision of the COC. Example, if the COC by voting share of 66 or more approve a plan that provide for an 80% haircut of the financial creditor, the dissenting financial creditor would have to accept the plan as long as they receive at least liquidation value of their claim. The right of dissenting creditor to proceed against the corporate debtor get extinguished by the virtue of the plan. However, the case of Ujas Energy differs from the typical scenario because the liability under the guarantee is not a debt owed by the corporate debtor. Instead, the guarantee is a debt of third party created through a contract of guarantee between a creditor and third party. The creditor, who is the beneficiary of the guarantee, may of course waive its right to claim under the guarantee, but this right be extinguished without individual creditor consent through a decision of the COC is a question. The IBC explicitly clarifies that CIRP only relates to the CD and its asset. As a consequences, the right of creditor vis-a-vis the corporate debtor. Given this is a questionable if the decision of the COC can take away the creditor's right to a debt owned not by the corporate debtor but by a guarantor. Further, while agreeing that a plan cannot deal with the guarantor's asset, the NCLAT judgment fails to consider whether resolving a personal guarantor debt without taking into account personal guarantor asset violate the creditor right in broader borrowing arrangement. So I must say that every such judgment will open another gate of question that whether approaching and whether seeking a consent of that particular creditor whose right is going to be killed, can a plan provides this kind of volume through which you can completely avoid or you can completely deciding upon the personal guarantor's liability, which is basically a right available with a creditor. So this is what I would like to say, because this matter went to the Supreme Court also, and Supreme Court has upheld the decision of the NCLT. So up till the time amendment comes into picture, I must say that resolution plan can also decide for the liability of the personal guarantor after the approval of the plan. Now, this is the very important question which I have highlighted here. I'm reading it again for the sake of a very big clarity that the case of Ujas Energy differs from typical scenario because the liability under the guarantee is not debt owned by CD. Instead, a guarantee is a debt of the guarantor created through a contract of guarantee between a creditor and third party. Creditor, who is a beneficiary to the guarantee, may of course waive its right to claim under the guarantee, but can this right be extinguished without creditor's consent through a decision of the COC? This is very important question. If he is a COC member assenting to it, it's okay. But if he is a member of the COC dissenting to it, you are stealing away his right by approving such a plan.
Overreaching, encroachment of right.
That is what my point is.
Correct.
And that's why I feel that this discussion is very relevant before reaching to the provisions. The IBC explicitly clarifies that CIRP only relates to the CD and its asset. And as a consequences, the right of creditor vis-a-vis the corporate debtor. Given this, it is the questionable if the decision of the COC can take away the creditor's right to a debt owned, not by CD but by a guarantor. Further, while agreeing that a plan cannot deal with the guarantor's asset, NCLAT judgment fails to consider whether resolving a personal guarantor's debt without taking into account personal guarantor's asset violates the creditor right in a broader borrowing arrangement.
Correct. गेहूं के साथ घुन भी पिस जाता है.
So basically everything sounds the reason was right, but at the end when you see into the question, now again there is an ambiguity whether such plan should get approved. If the plan is getting the necessary approval from 66% voting share, okay, it can dealt with the liability of the personal guarantor. But now what about the creditor in whose favor the guarantee was extended? If he has not consented to that plan, because this plan is killing the right of that creditor to invoke personal guarantee.
The general rule is majority prevails.
Now, sir, I would like to have from your side, because it was discussed initially that now there is some recommendation which are being called for in terms of this connection, that resolution plan cannot absolve the personal guarantor's liability. I would like to have your views on it.
It has its own repercussions, sir. It has its own repercussions. If you allow it, if you say that it cannot be done, then example I can give. For example, a corporate debtor and the promoter had a piece of land and 50-50 and 50-50 share, let it be. And then he has given his land for construction of the property, for building the plant and machinery shed or whatever you call it. Then what happens? Are you going to destroy 50% of the building and then take the land? It sounds a bit odd. It has its own anomalies with regard to this amendment which is going to be coming up in IBC, which has come up with that. They should address threadbare issues rather than giving a universal opinion or universal comment on that. This is my opinion, sir.
Absolutely.
They should
yes.
take.
Sorry.
Yes, sir.
By the help of the guarantee, if they have obtained the loan, in case of default, why should they be penalized?
Sir, if you can please be loud, because your voice is not clear to me.
By the help of that loan, by the help of that guarantee, if they have obtained the loan, in case of default, why they shouldn't be penalized?
Sir, if you can please write your question, it will be more clear to us, because or any other participant may please explain that question. I am not exactly getting it, sir.
Sir, I want to say, by the help of that guarantee, if they have obtained the loan, in case of default, why shouldn't they be penalized?
On the basis of the guarantee.
Yeah.
On the basis of guarantee.
If they have obtained the loan.
If they have obtained the loan. The CD has obtained the loan, right?
Right.
CD has obtained the loan on the basis of guarantee, all right?
Right. If the CD has defaulted.
CD has defaulted, okay.
Then why shouldn't the guarantor not be held liable equally?
That is the point, sir. Absolutely, that is the point we are discussing, that the liability of the guarantee or the guarantor's liability will not comes to an end upon approval of the resolution plan. That is the foremost law. The Contract Act is very clear that my liability will, or this is the contingent liability, that if the corporate debtor commits a default, I have to make the liability, I have to make the payment to the creditors, because creditor has extended the loan, has granted the credit facility only based out of the guarantee which I have extended. Now, the point which we are discussing is, if suppose that there is a CIRP going on with regards to that corporate debtor, and if one person is proposing a plan, the plan is proposed in such a manner that it is taking away the creditor's right of invoking a guarantee. And by the virtue of that plan, you are getting some consideration to relinquish your right to go against a personal guarantor. So here we are discussing upon the same question, that can a resolution plan be constructed, be prepared in such a manner so that the liability of the personal guarantor comes to an end upon approval of the plan, and the plan which is approved by the COC, because the approval of the plan requires the consent from those members who are having 66% voting share. There is a possibility that the creditor is falling within the domain of that 66%, the same creditor in whose favor the guarantee is extended. If he is agreeing to such proposal in the plan, it's okay. But suppose if he is a dissenting creditor who has not given consent to the approval of the plan, and still the plan, because of getting 66% approval, is getting approved, and keeping by approval of such plan, the liability of the personal guarantor or his interest is being safeguarded. But what about the interest of that creditor in whose favor the guarantee was extended? You are killing his right to invoke personal guarantee, and that is what we are dealing with, because this judgment of NCLAT has made it clear that resolution plan and the COC can also deal with the issue pertaining to you can say closing of the right, or you can say giving him an immunity, or by such plan you can decide about the liability of the personal guarantor, which is going to come to an end after approval of the plan. But is it so constitutional, or by doing so and by not taking the consent of that particular creditor in whose favor the guarantee was extended, is it right to do so without approaching and without taking the consent of that creditor first? That is what we are dealing, and that is what right now.
Whether any appeal or SLP is pending regarding this against the
No. This NCLAT judgment was challenged by the bank. It was challenged by the Bank of Baroda, but Supreme Court has upheld the order which is passed by the NCLAT in this case.
Okay, so now it has become final verdict.
Absolutely, sir.
Okay.
Sir, any citation of any matter like, any personal guarantor got the discharge certificate?
Sir, this is the order itself. NCLAT judgment in SVA Family Trust and others versus Ujas Energy.
No, sir, we are talking about repayment plan was approved.
No, not repayment, sir. This is the resolution plan.
Yeah, this is the resolution plan. Suppose there is failure of resolution plan, or this we are talking about during the CRP process, right?
Yes.
So I'm talking about the personal guarantee process. Okay. Okay, wherein there was no repayment plan, and the corporate guarantor has been adjudged, as a discharged.
No. Without having repayment plan, how come a corporate debtor? Because
no corporate debtor, but in the individual
personal guarantor. Personal guarantor will get a discharge order if there is a default in repayment initially, and if he is failing in bringing in the repayment plan to the committee or to the creditors.
So Vinit,
the same thing
which you have raised, I feel there is a prima facie.
Yes, please.
Yes, sir.
So point which you have raised, the prima facie, it looks like, the law of contract is, not considered, and it supersedes the IBBI law and judgment given in the particular case which you have discussed.
Correct. That is what my point is, sir.
But
from
then
the very
the
beginning,
constitutional, it cannot be, it will be challenged against, because it's a constitutional right.
Absolutely, sir. And contrary, I'm talking about the right of personal guarantor also. Because if I'm giving a guarantee, if I am successful in making repayment as a guarantor, now what about my right to be recovered from the corporate debtor? There is also the Contract Act which gives me a right to step in the shoes of the creditor of the corporate debtor. Subrogation.
Yes.
So suppose, sir, my question is still not actually, maybe I'm not clear. See what happens when the personal guarantee case is going on, and I'm unable to make any repayment plan. So I want to start afresh.
No, suppose, sir, if you fails to repay if you are failing in proposing any repayment plan, or suppose if repayment plan is not accepted by the creditor, right? Because it require an approval from more than 3/4 in majority in value. We will be dealing into that aspect, suppose. Now, if you fail to propose any repayment plan, or your repayment plan which was proposed by you, prepared by you in consultation with the RP, is not accepted by your committee of creditors or your creditors, in that case, there will be a clear-cut case of order of bankruptcy against you. What we have a liquidation in company, there will be an order of bankruptcy. How come you will get a discharge order?
So that means you will be adjudged as a bankrupt.
Absolutely. And so it will be, it will be an insolvency which will comes to an end, undischarged insolvent, and you will you will face the heat of bankruptcy proceedings.
Got it, sir.
So now we would like to have the provisions of section 94 and onwards up to 121. But just I would like to have a break of 5 minutes before we start. We will be starting the same at 12:55.
Okay.
होने वाला ही है।
Authorization, he will be moving an application.
So that means they will ICICI Bank will issue a authorization letter to initiate.
Absolutely. And that RP will be moving an application.
It's not suo moto kind of thing like.
Absolutely. And suppose if the creditor is moving an application, then in that circumstances, NCLT under section 96, under section 97, sorry, the NCLT is going to appoint the RP in this case, and RP has to submit its recommendation with regards to acceptance or rejection of the plan. So yes, this application can be either moved by the creditor or else on behalf of creditor by the RP. It is what stated through a RP to the adjudicating authority for initiating insolvency. Yes.
Through a resolution professional, that means it will save the time to get that application admitted for the want of appointment of RP, because it will take longer time.
Absolutely.
Okay.
Sir, here
Yes.
RP means the RP of the corporate debtor.
Here it is the RP, not of RP of the corporate debtor, an independent RP. And here also my views are, when we will be seeing or when we will be going through the regulation says that it cannot be the same RP who is the RP or the liquidator of the CD. I must say it should be the same
professional. I think it should be insolvency professional rather than resolution professional.
Absolutely.
It should be insolvency professional rather than resolution professional.
Here the RP means the insolvency professional who is eligible to act as an IRP or RP or the liquidator.
And the recently the circular is there that RP, even the RP of the corporate debtor will also be appointed as
absolutely, because there was a regulation. I'm just opening that regulation, and that regulation was required to be amended immediately. I'm just sharing because that regulation was not allowing the liquidator or the RP of the corporate debtor to act as a RP of the personal guarantor. Otherwise, my view is the RP or the liquidator of the personal guarantor is the best person who is knowing the personal guarantor in such case. So that's why that circular was required, that they RPs or they liquidator who are or who have committed a role or who have played the role of RP or the liquidator, they should be allowed to act as a RP in the process of the personal guarantor also.
I've just seen in the recent judgment in the matter of Rainbow, where the bank and all these things has proposed a separate insolvency professional as RP of that, but court has appointed the RP of the corporate debtor, Rainbow, as the RP of this personal guarantor.
Because he knows the in and outs, he knows the corporate debtor, its functioning, its personal guarantor, its director, the promoter, the co-promoter better than anyone else.
Correct. So this is
this was because of the regulation. I'm just sharing the screen with regards to regulation, which does not permit that the one who is acting as a liquidator or one who is acting as an RP of the CD is not eligible to act as a RP of the personal guarantor. But this clarification was only because of that restriction in the regulation, which will be amended shortly. I'm just sharing for the sake of requirement of all the participants. I'm sharing screen with regards to that.
See the footnote number 3, which is
Yes, yes, yes. So that is omitted.
Yes.
I'm just sharing. Is this visible?
Yeah,
Yes,
regulations.
yes.
So when you see the language or when you see the content, I'm more specific to this three star, which is omitted. Eligibility of the resolution professional. You can see the omitted portion. It is clarified that earlier the same was already there in the regulation, that a person has not acted or is not acting as an IRP, RP or liquidator in respect of the corporate debtor. So basically, it was not allowed when a person is acting as an IRP or as a person is acting as an RP or person is acting as the liquidator of the corporate debtor. He was not allowed to act as a resolution professional. I'm talking about Regulation 4 of this regulation, that is IBBI Insolvency Resolution Process for personal guarantee to the corporate debtor. Earlier, he was in the negative list or he was ineligible, and that's why it was required that this ineligibility should be wiped out, because the first person to whom the preference should be given is the person who acted as a liquidator or acted as a IRP or RP of the personal guarantor. Because once upon a time, the same IRP or RP or the liquidator must have moved Section 19(2) application. And during that stage itself, he must be knowing the intent of the personal guarantor or the legitimacy of the personal guarantor or the records of the personal guarantor better than any new incoming IP to act as an RP. So yes, it was restrictive earlier, and now it is again within the framework of law that they are no longer be treated as ineligible. Coming back to the same discussion what we had in the code, every allotted time for any discussion in the IBC is less. So 95 is the point of discussion we had. The creditor may apply under subsection 1 in relation to a partnership debt owed to him for initiating insolvency resolution process against any. So creditor is having a choice. The partners are not having choice if they want to go isolatedly. But creditors are having this choice that they can move against any one or the other partner of the firm, or they may go against the firm. Where an application has been made against one partner in a firm, any other application against the another partner in the same firm shall be presented in or transferred to the NCLT in which the first mentioned application is pending for adjudication. And that NCLT bench may give such direction for considering the proceedings under the application as it thinks fit. The application under subsection 1 shall be accompanied with detail and document relating to. So when a creditor will move an application, creditor need to mention in its application debt owed by the personal guarantor. I will not use word debtor. So debt owed by a personal guarantor to the creditor or creditor submitting the application for insolvency resolution process as on the date of application. Failure by the personal guarantor to pay the debt within a period of 14 days. I was talking about this aspect, that service of demand notice is prerequisite. I am on subsection 4 clause B. Failure by the personal guarantor to pay the debt within a period of 14 days of the service of demand notice. So even after the invocation of the guarantee, if personal guarantor has committed a default, it will be all right. But the creditor has to make it further clear that there was a service of demand notice to the personal guarantor, and this application is made after the completion of 14 days after service of demand notice. The definition of service is there in the rules. I'm coming to that. We contested one of the application wherein we successfully come out of it that service is not complete. Because if you move such application, the foremost requirement is you need to serve first. You need to serve me the copy of the demand notice. You need to serve me the copy of the application. And without proper service, this cannot be treated as a valid application. I'm just sharing with you the definition of service itself. Now, when you see the serve means sending any communication by any means, including registered post, speed post, courier, or electronic form, which is capable of producing or generating an acknowledgement of receipt of communication. In my case, the email was sent to the address available on MCA portal. And in the MCA portal, it is not the email of the personal guarantor per se which is available, but it is the address or the email address of the corporate debtor, upon which the control of the personal guarantor comes to an end immediately after initiation of the CIR. That email address was basically either being used by the liquidator in my case, or it was not even used by the liquidator. So the mail was served to me over the email ID of the company, that is a corporate debtor, which was never known to me. And thereafter, the application was also served on the same email ID. The email ID which basically, or which was originally, and even thereafter, was only related to the corporate debtor. So when the application, when I have received section 99 application, the first thing which I addressed before the honorable court was that no demand notice is served to me. The other side has presented the proof of service that pertaining to that email. And this is what I pointed out, that this email address is not pertaining to me. Other than that, my email ID would have been derived out of my DIN, but no efforts were made by the RP before moving this application. So on this technical ground, it went in our favor. So this can be the impact, or this can be the benefit one may take out of the definition, because definition is very clear. If it is returning unclaimed, then you have the another option available, that this document cannot be served in any of this mode, then it should be affixed at the outer door or some other conspicuous part of the house or the building in which the addressee resides or carries on the business or personally work for gain. So that is a remedy available. Suppose if my communication address, it is you, whatever you are serving is returning unclaimed, then this should be pasted outside my premises, the place where I'm residing or the place where I ordinarily carrying on my business or gain or personally working for the sake of some gain. So again, coming to the same discussion that service is mandatory before initiating.
Sir,
Yes.
suppose I pasted a CAPTCHA or and it has been removed subsequently. Then how to prove that?
Please come back to your question again.
I said, we are talking about, suppose if the mail or the post has been returned as undelivered. So in that situation, one is required to, paste it, where the personal guarantor resides, right? So suppose I have pasted it, and subsequently after half an hour,
produce all the evidences that provision or that rule is duly complied. You have all the modes to produce it before the tribunal. The honorable tribunal is going to rely upon the photographs which you have taken at the time of affixation. Yes. Give a public announcement if required.
Sir, suppose the address mentioned of the corporate this personal guarantor, and personal guarantor left the place long back and we are not knowing where he is residing. So what, if he has changed, somebody else is residing over there, then...
Sir, what I believe, if we just go by the definition of the service, it is very clear that it is not important whether he is residing to that address or not, whether he is available to that premises or not. What we are going to rely upon, the address of the personal guarantor which is available on the public domain. Now, suppose if we talk about the directors who are acting as a personal guarantor, or against whom you are moving an application as a personal guarantor, if you wanted to extract the data, there is always a DIN through which you can get the data available, that what exactly his address, the permanent address or the present address, you can identify. Now, suppose if you have not complied with the requirement of the KYC, then better you just approach the registrar, because ROC must be having the last known address of the person to whom even they used to serve the notice. So when the government department is serving any notice to the last available address, you don't have any recourse other than opting for the same address for the sake of pasting that notice outside the premises. So again, and now it is again, another thing comes, if no such address is in existence. It happens that the available address is no more practically available if the address which is specified with regards to his residence, if it is not available, then in that case, you always have recourse to approach the honorable tribunal, and the provision is there, what you have under section 19(2). The same provision is also available in this personal insolvency procedure. So other than that, you cannot go beyond what the address is available with the public authorities.
Sir, may I raise one issue, sir?
Please, sir. Please, sir.
Okay, sir. I have seen in one of the cases, okay, the address given in the bank record is wrong. So, can the bank say that there's in the loan agreement there is a clause whenever the borrower changes his address, he has to inform the bank. Otherwise, if he does not inform, any notice served on the address available with the bank last known address is as good as
very correct.
So, can we take that?
Absolutely, sir, and
That should be
absolutely.
done. So whatever
And that defense is going to be absolutely that. Is that audible?
You're audible, sir. What
Yes,
I
sir.
stand, I am
So
taking.
what stand you are taking is absolutely correct. I will
happened
go
in
by
my case-
whatever is there in the agreement.
So what I am doing, say I've been appointed as an RP for that 99 report. I served the 99 report on the mail ID, which is again, as you said, it's a company's email ID only. I don't know whether that fellow has, that director has that access to that or
Sir,
not.
I
Okay, no, but we
think
couldn't do
that
anything else.
serving such notice to the email ID of the corporate.
Okay, that's one. So plus hard copy also was sent. In the hard copy when I sent it, there are 3 guarantors. One guarantor received it, another guarantor rejected it, third guarantor was returned saying that address changed. Okay, in that, so what I asked the bank, do you have any other address? Banks doesn't have any other address. So am I audible or? Hello? I think my internet is a problem. Or?
No, you are audible, Mr. Ravi.
Okay, his internet has a problem.
You are audible, sir.
Okay, I think his internet has a problem. So I asked the bank that do they have any alternative address or email ID? They don't have any other email ID, bank, except the corporate debtor's email ID, because all the 3 guarantors, no, they didn't give the personal email IDs to anybody. So we sent to him, and the address it was sent out of 3 guarantors. One person received it, second person refused it, third person returned saying that addressee is not found or addressee is not there, something like that. So when I asked the bank, they came with me this solution, saying that in the loan agreement there is a clause which says that whenever there is a change in address, he has to inform. If he does not inform, the last known address is if it is served, is as good as served only.
Personal email ID is available in the DIN. If you retrieve from the DIN, you can find the personal email.
No, but can I access his DIN details with the DIN number? I think I need his date of birth or something. No, date of birth. Oh, no, just by logging into his DIN number, can I get his details?
DIN details, I think it can be retrieved.
By simply putting the DIN number?
No. I think there is some
You can
charge.
identify out of DIN details, but again,
no, DIN
is I'm
sir, I
audible?
have his DIN. You're audible, sir. Now I have his DIN
Yes.
number.
So you can easily identify out of DIN details, but make sure he is taking care of regular compliance of updating his KYC. Now, suppose if KYC is not updated
Okay,
with
yearly
regards to
KYC,
his
yearly
DIN,
KYC is
you will
not
not be in a
done.
position to, yes. So every year there is a mandatory requirement that you
Right.
should undertake KYC compliance for every
Right.
directors. So
Okay.
you are all within your power to address to the same address which is relied upon by the bank, and there is no further requirement to identify upon where the persons are ordinarily residing if the
Right.
address at which you are serving is returning unclaimed, sir.
Sir, there's one more issue is that you said you can paste it on his address and all that, but before getting the 99 report and order, can we make his name public in the sense that we are not supposed to make a public announcement or announce to anybody? No, suppose somebody comes and pastes something on my door without getting the
Sir, you are right. My point is with regards to communication of demand notice. Now I know that right now application is not admitted against me, but if the first, the basic requirement is whatever demand you have, that demand should be addressed to me. Now, if you are not in a position to trust me, if you are not in a position to communicate me, tomorrow the same person will take a stand that I have not received the copy of demand notice. So for the sake of communicating, it is important that by pasting such demand on the premises will not hamper his image, because it is just a notice of demand and this is not an intimation of insolvency against him to the public.
Okay.
So where an application has been made against one
Thank you,
partner,
sir.
so we have done with, yes, sir. The creditor shall also provide copy of the application made under subsection 1 to the debtor. This is very important, that even section 95 says that after service of demand notice, suppose if no reply is received or no payment is made by the personal guarantor, then before moving such application, the creditor shall provide copy of the application to the debtor. Subsection 6 of section 95, the application referred in subsection 1 shall be in such form, so that is pertaining to the rule. Details and documents required to submit it shall be such as may be prescribed. So that is pertaining to the rule. 96. Now this is very important. When the interim moratorium shall commence. So interim moratorium will not commence from the date of making an application. It is very much clarified by the court of law that this application should be scrutinized and should be numbered. And then only it will be treated as if the application is made and interim moratorium has commenced. So when an application is filed under 94 or section 95, an interim moratorium shall commence on the date of application. One should not take it a lenient view by stating that the application was made or the e-filing was done. The interim moratorium shall commence on the date of application. Make sure this application should have been scrutinized by the registry and the case number is allotted. Then only it will be treated as if the application is made in relation to all the debt. Shall cease to have effect on 180th day. On the date of admission. So on the date of admission, further moratorium will start and that will extend till 180 days. During the interim moratorium, any legal action or proceeding pending in respect of any debt shall deem to have been stayed. So the NCLT with this assumption and with this to take the benefit of interim moratorium, NCLTs are not casual in its approach while admitting section 94 application. Interim moratorium period, the creditor of the debtor shall not initiate any legal action or proceeding in respect of any debt. Where the application has been made in relation to a firm, interim moratorium shall operate against all the partner of the firm as on the date of application. The provision of subsection 1 shall not apply to such transaction as may be notified by government in connection with financial sector regulator. Till date, there is no transaction identified or placed in a public domain. 97. Appointment of RP. The same person through which the application was moved shall be acting as an RP. If the application is made through RP, and if application is made by a personal guarantor under 94 or by creditor under section 95 with no such recommendations of RP, then NCLT is going to appoint RP in this case. So not that relevant provision to go through, and I will be dealing with section 98, which talks about replacement. Where the debtor or the creditor is of the opinion that the RP appointed under 97 is required to be replaced, mark my words, this replacement can be possible even after the completion of the insolvency process and during the course of implementation of the repayment plan. Yes?
Sir, I want one query. If one
Yes,
RP is
sir.
appointed, based on the application of one
Okay.
FC, can another FC file a case?
Sir, when already a person is appointed and application is admitted, the other application will not be entertained. The same thing. Once a corporate debtor is admitted in CIRP, how come the other application will even survive?
Right.
So 98 talks about replacement of the RP, and this replacement application can be made by a debtor or creditor as the case may be. So where the debtor or creditor is of the opinion that RP appointed under 97 is required to be replaced, he may apply to the NCLT for replacement of such RP. Adjudicating authority, the same thing, adjudicating authority will appoint a new RP against whom no disciplinary proceedings are pending. So this is not that relevant. Where the adjudicating authority admit an application, I'm here on subsection 5. Or subsection 4 is also relevant. Without prejudice to the provision contained in 1, the creditor may apply to adjudicating authority for replacement of RP where it has been decided in the meeting of the creditor. So meaning thereby there is a provision which talks about the meeting of creditor in this resolution of the insolvency of the personal guarantor. To replace the resolution professional with a new RP for implementation
Seems that your net is not stable.
So
I think your net is not stable.
is that audible?
Yes.
So wherein adjudicating authority admit an application under subsection 1 or 4, it shall direct board to confirm whether any but this generally does not happen. They never approach board for seeking confirmation with regards to new candidate, and they have empaneled IPs to whom they can appoint as an RP. Submission of the report. Now, this is the most crucial stage, which either take out the process up or else it may end up with the process. Now, RP has a big role to play, but these days I've seen RP generally relies upon just as an application. They put a recommendation for admission and applications get admitted. So RP shall examine the application under 94 or 95 as the case may be within 10 days of his appointment. So RP will be appointed if the RP application was moved by the RP itself in section 95 application, the appointment order was confirmed by the adjudicating authority. But suppose if the application was made by the creditor and NCLT has appointed RP in this case, so RP within 10 days of his appointment shall submit report to the adjudicating authority recommending for approval or rejection of the application. During this phase, I must say that RP need to or RP is required to reach out to the personal guarantor. Even if I said, if the application is moved by the personal guarantor himself, this is not going to be a troublesome process. But if the application is moved by the creditor, then in that case, RP should make an attempt to reach out to the personal guarantor first. The RP shall examine the application referred to in 94 or 95 as the case may be within 10 days of his appointment and submit a report to adjudicating authority recommending for approval or rejection of the application. Where the application has been filed under 95, RP may require debtor to prove the repayment of the debt claimed as unpaid by the creditor by furnishing. So debtor should be given an opportunity to furnish by the way of evidence of electronic fund transfer of unpaid amount from bank account to the creditor evidence of encashment of the check. So he should be given an opportunity wherein he can able to demonstrate that check was issued in favor of the creditor which is encashed, or sign acknowledgement given by the creditor accepting receipt of the dues. So he is supposed to reach out and communicate to the personal guarantor before giving any recommendation pertaining to acceptance or rejection of the application. Where the debt for which application has been filed by the creditor is registered with IU, the debtor shall not be entitled to dispute the validity of such debt. So the lodgement with IU is deemed as accepted by the personal guarantor, and personal guarantor will not be in a position to further dispute the validity of that debt which is already registered with NESL. For the purpose of examining an application, the RP may seek further information.
Sir, dispute here means because it is already a dispute. So why Section 7 application has been admitted. So again,
No, dispute, sir. Dispute is with regards to the invocation of guarantee. Here I'm not talking about the pre-existing dispute before admission of application. Any sort of dispute with regards to execution of the deed of guarantee between a guarantor and a banker.
Okay. And sir, one more
it's
thing.
Not about
One more thing. So what is the prevailing fees of RP?
Sir, it depends upon who the RP is.
No, sir, because I think there is a minimum threshold limit of 1 lakh is applicable. I wanted the clarification in that regard.
This generally happens in CIRP. For this matters, I have not seen any NCLT passing an order of 1 lakh.
Yeah,
Right.
Silent.
It's mutual.
Sir, let us wait for some good time to come, because this is not a topic wherein I will be putting any, and because my any figure will probably will maybe not a right figure, because it depends upon RPs to RP and their experience. Yes. So this cannot be answered at this moment.
Sir. The Hyderabad MCLT is giving 50,000 towards expenses. But I don't know what expenses.
No, that is correct, but there is no benchmark for all which is set forth by the IBBI. That is what my point is.
The last regulation when IRP fees was modified, giving a minimum of 1 lakh rupees and based on your creditors.
Correct, sir. But there is no regulation, personal guarantor regulation for which such things or such issues are addressed.
Yes, correct. There are stages. There are 2-3 stages: pre-admission, post-admission. So there is lots of confusion in fees also. So then there is no fees has been fixed by the IBBI also.
Okay.
Resolution.
In one of the case, I have charged 2 lakh rupees for preparation of report.
For preparation of. So this is what I said. It depends upon who the person is, with what caliber is sitting, with what experience is sitting, with what luck he is sitting.
Yes.
So RP shall examine the application referred in 94 or 95, and while recommending, he should give an opportunity to the personal guarantor to showcase the fact that whether he made the payment or not. Where the debt of the application has been, where the debt for which the application is filed by the creditor is registered with IU, then debtor shall not be entitled to dispute the validity of such debt. For the purpose of examining the application, very relevant, for the purpose of examining the application, the resolution professional may seek further information or explanation in connection with the application as may be required from debtor or the creditor or any other person who, in the opinion of the RP, may provide such information. So in the recommendation, you should mention that what efforts you have made to showcase the legitimacy of the dues or the debt which are there in the application. The person from whom the information or explanation is sought shall furnish such information or explanation within 7 days of the receipt of request. RP shall examine the application and ascertain that applications satisfy the requirement of 94 or 94. Whether the applicant has provided information and given explanation, this is very relevant. Whether the applicant has provided information and given explanation sought by RP. After examining of the application under subsection 6, he may recommend acceptance or rejection of the application in his report. I have not seen personally any RP recommending for rejection of the application. Where RP finds the debtor is eligible for fresh start, let us not touch upon that side, which is not right now implemented. RP shall record the reason for recommending the acceptance or rejection of the application. RP shall give a copy of the, very important, the constitutional validity of 95 to 99, which was challenged, and this is the outcome. The RP shall give a copy of the report under 7 to the debtor or the creditor, as the case may be. Now, this, as the case may be, is not taking its literal view. You need to, or you are bound to, or you are duty bound to serve your report to the personal guarantor during the course while submitting an IA before the adjudicating authority under section 99. You are bound to produce the proof of service of your report to the personal guarantor while moving an application under 99. Section 100, which talks about admission or rejection of the application. So it is now the adjudicating authority who will be within 14 days from the date, and you know the timeline as are recommendatory and not a mandatory, just a directory. Adjudicating authority within 14 days from the date of submission of the report pass an order either admitting or rejecting the application. Where adjudicating authority admit an application, now this is very important, because in CIRP it is the role of IRP for a public announcement, for invitation of claim. But when you see in personal guarantor cases, adjudicating authority upon admission of the application under subsection 1 on request or RP issue instruction for the purpose of conducting negotiation between a debtor and creditor and for arriving a repayment plan. Now this is important. Adjudicating authority shall provide a copy of the order passed under 1 along with the report of RP and the application under 94 and 95 to the creditor within 7 days from the date of order. So I, as a creditor, can approach tribunal can ask for the copy of application. I can ask for the copy of the report of RP. If the application referred in 94 and 95, as the case may be, is rejected by the adjudicating authority on the basis of report submitted by RP, that application was made with an intent to defraud creditor or the RP, the order shall record, the order under subsection 1 shall record that creditor is entitled to file bankruptcy straight away.
Okay, thank you.
Moratorium. So here the interim moratorium will comes to an end and moratorium will begin, because here we used to call commencement of CIRP and here we used to call commencement of the insolvency resolution process of the personal guarantor. It will also extend to 180 days. So when an application is admitted under 100, a moratorium shall commence in relation to all the debt and shall cease to have effect at the end of the 180 days, beginning with the date of admission of the application or on the date adjudicating authority passes an order on repayment plan. So whichever is earlier. In CIRP, the moratorium will commence till the CIRP continues. Once the resolution plan gets accepted or the liquidation order get passed. During moratorium period, any pending legal action or pendency in respect of the debt shall deem to have been stayed. The creditor shall not initiate any legal action or proceeding in respect of debt. Debtor shall not transfer. Now this is, but there is no 4366 things which are there in this case. The debtor shall not transfer, alienate, encumber or dispose of his asset or legal heir or beneficial interest therein. But there has to be some restriction prior to admission. Moratorium के बाद तो नहीं कर सकता है, but moratorium से पहले अगर किया है तो कोई look back period नहीं है, कोई प्रोविजन नहीं है जो आज 43 और 66 में we used to study and we used to deal with. So of course upon initiation of moratorium, the debtor is not able to transfer any, encumber or any of his asset or of his legal heirs or beneficial interest therein. When an order admitting an application under 96 has been made in relation to a firm, the moratorium shall operate against all the partner of the firm. So this is something which I feel that moratorium shall certainly restrict, but what about the restriction prior to commencement of the insolvency against the personal guarantor? Debtor, there has to be some look back period or there has to be some provision which talks about a fraudulent transfer or fraudulent preference or some extraordinary transaction which is there in the process of CIRP or liquidation. So
Here,
debtor after the admission of, yes sir.
here after this admission, this RP cannot take the control of the assets of this creditor, unlike CIRP.
So, sir, in that case, the control over the asset will be with, that is going to be with RP only, because when he will not be in a position to transfer, alienate, encumber or dispose, so ultimately control will shift it to RP only. In fact, if some personal guarantor is carrying on its business, so that business will also be going to be taken care of by the RP. What we see in case of IRP, RP doing his job to keep the corporate debtor going concerned. So the control will of course shift it to the RP only. If the control will stay with the personal guarantor in that case, if the controls are with the personal guarantor, then they will be in a position to transfer, alienate or encumber. So meaning thereby they cannot have this right to transfer, alienate, encumber or dispose of any of his asset or asset of his legal heirs or the beneficiary.
It will be very difficult to find out the bank details and other details because they do not share all these things.
That is what we initially discussed in the very first over of this match.
Yes, yes.
But sir, RP in any case can move an application for all this kind of avoidance transaction, alienation and all if he comes across.
Sir, there is no provision pertaining to whatever has been done in the past. But yes, during the course and after the commencement of the insolvency process of the personal guarantor, very well he can move before the adjudicating authority to get the necessary orders.
Okay.
Now, public notice. Now, this public notice is the responsibility on the part of the adjudicating authority. If you can see this, adjudicating authority shall issue a public notice within 7 days of the passing of the order. Shall issue a public notice within 7 days of the passing of the order 100 under section 100, inviting claims from all the creditor within 21 days of such issue. So unlike what we have in CIRP within 30 days from the commencement of the CIRP, this is within 21 days from the date of issuance of public notice. And that's why you will find outside the NCLT courtroom, you will find a public notice board wherein such notice get affixed. The notice under subsection 1 shall include detail of the order admitting the application.
Here, RP is not required to issue any notice. Public notice.
When you go by section 102, no. But generally the orders are being passed. Otherwise, you will find outside the
format. There is no format of notice.
Correct, sir. Correct.
Sir, and that's why he is saying that NCLT says that the RP is required to make the public announcement and submit it before the AA.
Yes.
Fixation on the registration.
Absolutely. So that is what practically being done. But when you go by the requirement of 102, the onus of issuing public notice is on the adjudicating authority. And that's why you will find almost after, you'll find this in all the NCLT benches in the public notice, you will find this public notice get affixed. And this is what provided in subsection 3. The notice shall be published in English and vernacular language newspaper and shall be affixed in the premises of the adjudicating authority. And that's why these days you will not find any corner left unused. Affixed in the premises of the adjudicating authority and will be placed on the website of the adjudicating authority. So I need to check the website of the adjudicating authority. I have not seen website of the NCLTs. So they need to keep their website updated with regards to this notices.
So how does an RP after publication of public notice submit the public notice with NCLT?
Why not, sir? If I will be directed to give a public announcement, what we used to do in form number A, that is public notice inviting claim, the same thing here we need to mention that this is the corporate or this is the corporate guarantor or this is a personal guarantor against which the application is admitted and claims are invited to be submitted within a 21 days from the date of the issuance of this public notice. And I need to lodge a copy along with an affidavit before the adjudicating authority. So my reporting obligation will come to an end the moment I will report the fact that publication is done along with the compliance affidavit before the adjudicating authority.
So once you file public notice, you make an application with NCLT that this compliance has been
Not
done.
required, not required. I am not supposed to move any application. I simply file an affidavit stating the fact that since I was directed to give a public announcement, and by the virtue of this provision, the public announcement is made within 7 days from the date when order was made in public domain. And I'm placing before you the copy of the newspaper publications.
So the process followed in Mumbai is that we give a letter, a request letter to the registry of the NCLT
Absolutely.
with a request to put it on the notice board and put it on the website.
Absolutely. And this is, and I feel that there is no requirement that for this intimation, I have to spend 1,000 rupees for moving an IA and to put any cost on this process itself, because I have to engage an advocate for that.
Right.
Okay.
I'm moving with 103. Yes, sir.
Just one more thing. I think the claim of whoever is the claimant over here is they have to file the claim till the date of Section 100 order, right? The interest will be calculated till 100 order.
Absolutely, yes. Absolutely, yes.
So
whatsoever my claim is, as on the date of because in the corporate debtor also, we used to follow the same practice. Whatever amount is due and payable as on the insolvency commencement date, I'm going to claim that amount.
Not as on Section 95 order date, but Section 100 order date.
Absolutely, because based out of 95, the matter reaches to 99. And based out of the report of 99, the matter reaches to 100. So I believe that I should be putting my claim as on the date when that application was admitted and order was passed.
Yes, and in many cases, I think in majority of the cases, wherever these personal guarantee orders are passed under 100, in majority of the cases, CRPs are already going on, and they are not concluded generally, and there might be resolution plans are pending or whatever it is. So even in those cases, the claims of those creditors are not crystallized. I mean, what extent they are settled. So what is happening over here is that there are duplicacy of claims. So a claim is filed with the RP of the corporate debtor, and then
as well as before the RP of personal guarantor.
And then an enhanced claim, because the CRP must have commenced a year before, and then an enhanced claim is being filed with the resolution profession of the personal guarantor. So there are double claims. So the problem over here is that, I mean, yes, of course, you'll cover it in the repayment plan. How a repayment plan would come in such a matter wherein the personal guarantor himself is not aware that what will be the realization of the creditors under the CIRP. How a repayment plan will be given over here.
Absolutely. But if you see in CIRP, basically, the claimants are the claimants of the corporate debtor. Claimants are the claimants of the corporate debtor. In case of personal guarantor cases, the claimants are going to be, the only person common is going to be the financial creditor. That's it. Other than that, see, my liability was akin with the corporate debtor's liability. Since the corporate debtor has committed a default, then ultimately it is me from whom the other party or the banker is claiming. So I think the only common creditor is going to be the bank who initiated an insolvency proceedings against me for the balance amount which they failed to recover even out of the resolution plan. The rest of the creditors are going to be the creditors of mine and not the creditor of the corporate debtor. So I don't think so that...
So practically only those financial creditors who have initiated the personal guarantee matter, they'll only file the claims, and most of them.
Absolutely. Because public at large is not so vigilant these days that they can able to identify that I have to claim some amount, and even they don't have anything to substantiate their claim.
So even in personal books, only claims like, other than personal guarantees, claims like unsecured creditors or small liabilities are there, and they never file their claims generally.
Absolutely. So, and if you see their balance sheet, you fail to identify their own creditors.
Exactly.
Today, me and you are filing. See, we both are filing our individual returns, but in our returns, we are not disclosing कि मैंने किसको दिया है या मुझे किससे लेना है. We rarely take care of it. So in that circumstances, quite difficult for even RP to identify that from where the RP is going to verify the claim is the topmost question.
Absolutely.
So registration of the claim by the creditor. Here I would like to say the timeline is...
I'm sorry, Vinitji, Kshitiji was telling that there will be a duplicacy of the claim by the same creditor.
Absolutely, yes.
So how it will be dealt? Like
Sir,
they are claiming it will be part of the resolution plan. Suppose 100 crores loan is there, one bank. and he has filed claim of 100 crore with the RP of the CD. Now again he has filed 100 crores with the RP of the individual, this PG. So how this RP will deal all this? Suppose he's taking, his registration plan is pending, or the CRP is still going on. So
sir, I would like to say yes. I'm coming to that, sir. I'm coming to that. In that case, suppose if the CIRP is going on,
yeah,
if CIRP is going on, there is all the possibilities that this corporate debtor may get a resolution plan. If the corporate debtor will get a resolution plan, then whosoever is against me is the secured financial creditor. Secured financial creditor is standing on the top of the hill under section 53, read with section 30 also. So there is a huge possibility that whatever is the claim which he made before the RP of the personal guarantor is going to be reduced to that amount, which is going to recover out of that plan, meaning thereby up till the plan get its finality, up till the time the CIRP reaches to its finality, it is impossible for me to held liable for the entire amount.
So, sir, in that case, because there are restricted timelines to submit the repayment plan over here, and the CRP, you know, it goes on till eternity. So, what to
that
do
will get extended.
How will a guarantor submit a repayment plan कि एक ही 100 के against में इधर 100 दूं कि उधर 100 दूं?
यहाँ पे तो सर अगर आप टाइम देखेंगे तो it is hardly a time of 50 days. We will be coming to that part, but I must say that there is a provision wherein the RP can approach the adjudicating authority for seeking an extension. And I will be insisting, because I will not be in a position to draft my plan if there is no clarity for what amount I will be held liable as a guarantor.
Correct.
This issue will even not get resolved if the CIRP fails and liquidation commence. Because if the liquidation commence, in that case, if there is a collateral, section 52 permits secured creditor to stay out of the liquidation and enforce the security interest. If they will be enforcing security interest, then in that case also the claim amount should be substantially reduced, because they cannot claim an amount which is already they are getting in the process of the SARFAESI.
So that is what my personal guarantor is saying, ki boss, you are the bankers are already recovering in the resolution plan. It is not approved. I have no control over that. Against their 100 rupees debt, they might get 100 also. They might get 80 also. What repayment plan should I give to you today?
And that is what my stand is, sir. I, as a litigator, I'm not thinking from the perspective of the RP, but I, acting as a litigator, I am before the NCLT Ahmedabad bench in one of the case. I'm mentioning that application is not fit right now, because whatever amount a banker, the SIDBI is claiming in my case, whatever amount the SIDBI is claiming, the corporate debtor is already sold as a going concern. And if the corporate debtor is sold as a going concern, he is getting something out of it. So let the application should be amended first.
So if there is a wait and watch of the situation, then, so just a moment, So if there is a situation of wait and watch, Mr. Mehdi, can you mute yourself, please? So if there is a wait and watch situation, then intent of section 128 of the Contract Act will be defeated.
100%, sir, 100%. But see, I will see from the viewpoint of the personal guarantor that for what reason a person can brought a claim before me for an amount which in any case he is going to recover out of the asset of the CD. Because my entire plan is depending upon this big amount.
Yeah.
Other than that, I have all the small creditor, those who have not even placed their claim. So what I am more interested is what benefit I'm going to get out of the CIRP or the liquidation, and what amount will be substantially reduced. Because unless and until I will be having that budget in my mind, I will not be in a position to propose any plan.
Absolutely.
And there is a full certainty.
We approach the NCLT to seek, the process to be kept in abeyance till that plan is approved or the liquidation is finalized.
That is, and that should happen, sir. That should happen.
Is there any precedence to that, Mr. Nagar?
What, sir?
Is there any precedence to this so that we can also approach in our matter, because it is unlikely that the personal guarantor will give any plan?
Sir, I will certainly work upon it, because there are multiple applications wherein I am representing the personal guarantor and the CIRP is recently completed. And those corporate debtors have been sold as a going concern. Now, if the corporate debtor is sold as a going concern, then I should not be, or the claim should not be of that amount which you have already placed and which you have already recovered many things out of it. So by the virtue of this fact, this application itself deserved to be rejected.
Right.
Because the amount stated in the application is not the rightful amount which he is entitled to claim through this application.
So one question on statement of affairs. For that, personal guarantor has to provide information.
Correct.
So what if he does not provide? You move an idea?
Absolutely, because statement of affairs is the basic document through which you are going to identify the claims which are coming your way. Are the legitimate claims in the books of the person or not? And if you are not having this information, you don't have any foundation on the basis of which you can able to take care of the insolvency resolution process.
Okay.
Yes. If I see the clock, it's already 2 o'clock, and this is what my biggest concern was, that this there is no end to any discussion when it comes to the matter of IBC, because at this moment the problems are not resolved, and that these are being resolved temporary out of the order. And when the orders are being challenged, we can say that yes, what was upheld or what was set aside by the NCLAT and Supreme Court was the right law. So basically, at this moment, I will request ICSI IIP to give one more opportunity to actually address upon the issues which are left unaddressed.
Sir, with regard to the statement of affairs, there is one document which is available with the bank. When you sign a personal guarantee document, you are supposed to produce your statement of affairs.
Correct.
Which is normally cooked up. Nothing more than
or
that.
else if it is now, it should be treated as a age-old document.
It's an age-old document. For example, when you take the renewals, it is taken at the first instance. For example, if a loan is taken 10 years back, normally every renewal has to have the personal guarantee being, renewed or whatever you call it. They always normally take the previous one, and it is 10 years old, means you will have a statement of affairs which is 10 years old. And by this time, he would have completely, disseminated or whatever he would have done with the asset. That is one thing which is there. But statement of affairs is available with bank. That's what I wanted to convey.
Sir, in some matters, the bankers are even asking
can we approach the income tax department to, get the last balance sheet or last statement filed with them?
No, it cannot be done, because for the simple reason being, you don't file statement of affairs. Even if you file statement of affairs in your personal taxation, there is one thing which is there only for a businessman, not for a person who is a director or something like that. If he gets only salary.
In any case, income tax return is not accessible to any RP or IRP.
No, it cannot be done. You have to get it from the personal person. That is what is the point.
And suppose the order of NCLT is there directing income tax department or any other statutory bodies to provide documents, that is also possible.
Then it may be, but the thing is that it's a kind of up till now I have not seen any order passed by NCLT directing any income tax officer to produce their income tax return.
But that is shortly going to be the case, because other than authorities, there is no reliable source from where you can get the information. In company, there is always a possibility you can able to identify the auditors of the company. But for a person, it's impossible for you to identify who was taking care of his individual returns.
And even if you try to get those returns, what will happen is the hierarchy will come into the picture. I need to get this approval, that approval, then only I can do it. Even when the case of filing with regard to income tax department, filing the case with regard to operational creditor, they find it difficult because it is, the hierarchy and the other things which play a vital role.
Absolutely, yes, sir.
Vinit, just one question I have. One question. Since we could not reach till the list of creditors thing. Now, when we receive claims, so generally in personal guarantee matters, claims are submitted only by the applicants, right? But when we have been made available with data, like the personal guarantors might have given guarantees to other lenders as well, but they did not submit their claim. Now, when the repayment plan comes, how will the repayment plan, so that repayment plan will be based only on the basis of claims or that has been received?
Based on, yes, sir. So coming to that, based on the claims I have received, I have to prepare the list of creditors. So based on the claims which I have received, I am going to prepare the list of creditors. And while the list of creditors are before me, I will be only confined to the liability. What we have information memorandum in CIR. Information memorandum relates to all the liability of the company or a corporate debtor. Here, I know that these are the claimants, because in this process, everything is transparent. Whatever claim is coming to the RP, the same fact is known to the personal guarantor. So I will confine to that process, or I will confine my plan only to that amount for which, because I am in insolvency, the public notice was given to all the creditor to lodge their claim. Now, the one who is not lodging the claim is losing his right to recover thereafter. So I will confine that.
The concern of personal guarantor is that he had given 2 guarantees in different companies. Now he's saying that in this case, the applicant has filed their claim, but in the other guarantee, the other corporate debtor, that bank has not filed their claim. Now, when I'm going to submit my repayment plan, should I?
So the question is, sir, the question is whether the other banker or the other company for which I am also a guarantor, whether the other banker has invoked the guarantee or not.
They have. They did.
If they have invoked the guarantee, yes, if they have invoked the guarantee, and still if they have not filed the claim, if they have not lodged the claim, the same formula apply, that there will be an extinguishment of the claim after the approval of the plan.
So they need not provide in the repayment plan, the PG need not provide any payment against those unclaimed liabilities.
Now it is up to you. Now in that case, you being an RP plays a dominant role. If you are aware of this fact, then in that case, it is a responsibility on your part to intimate all those creditors which you are aware of or which you are privy to. Now, suppose if you are the RP aware of this fact that Vinit has extended guarantee on behalf of one Bangalore-based company or one Delhi-based company in favor of Bank of Baroda and SBI, and Bank of Baroda and SBI, they have not invoked the guarantee, then in that case, you should inform them. And even otherwise, if they have invoked the guarantee and the liability is still there, and there is a default in repayment, then in that case, you need to place it before the creditor, or you need to, because ultimately the plan will be prepared by him in consultation with RP. Plan will be prepared by personal guarantor in consultation with RP, and this will be proposed before the creditor. So you need to be very clear while proposing the plan of the personal guarantor before the creditor that these are the liability which are standing, these are the creditor, those who have not submitted the claim. And in that case, if the amount is on a higher side, which you are aware that the plan will not be in a position to accommodate, if not before the creditor, then you need to be very clear before the adjudicating authority, because you are the officer of the NCLT. And no NCLT is going to approve such repayment plan even after the approval of the plan by the creditor. Here you will find the difference. Unlike in corporate debtor CIRP, there is no power of the adjudicating authority to direct for the amendment. Here you will find the power is with the NCLT to also give a direction for amendment in the plan.
Okay.
So being a RP, it is the foremost responsibility that if I'm aware of the big creditors of the personal guarantor, big or small, if you are aware that if they have not filed a claim, then you need to intimate them that they should file a claim.
The only problem is over here is that there is a deadline to submit the claims. There are no precedents we can extend, we can accept the claims even after the last date as was there in the public announcement. When I'm coming, when it is coming to my knowledge that there are other creditors or maybe bankers, when I'm intimating them, I cannot tell them.
Probably the train must have left. Correct. You're right.
I cannot condone the delay on my behalf.
Sir, you are not supposed to condone the delay. You have done your job by intimating the same. It is their headache, it is their trouble. Now, it is their litigation which they need to give or justify before the court of law. Let NCLT to hear them, let NCLT to allow them, because it is not your responsibility that within a time frame of 21 days, they should also lodge their claim.
So I should ask them while intimating, should I ask them to now move to NCLT if they want their claim admitted?
Absolutely not. No. This is their advisor's role, sir.
I should just intimate them that it has come to my knowledge about this liability. That's it.
So taking
you
this
simply, no. You are not even supposed to mention that I come to knowledge of this liability.
Yes.
You are intimating the same fact which you have intimated in public announcement.
Correct.
Why you will No. Why you will invoke them that come and lodge a complaint? Come and lodge a claim. No. You are intimating the same public notice to them, which you have publicly informed to the public at large.
Okay.
Suppose, sir, the personal guarantor has made the contingent, I mean, that adjustment. Suppose it is not known for other liability, for other guarantee given to other banks.
Will comes to an end if the plan is approved. Contingency of liability will, that is not a debt as on the liquid. See, what you can lodge is the debt which is outstanding or the claim which is there on the commencement date of the insolvency. Contingent claim is claim wherein default is not arise yet.
No, I'm talking about with reference to the claim which is not known, which has not been disclosed.
Sir, claim which is not disclosed, so RP has its own duty to check and verify, because if one is putting a claim before the RP has to identify the legitimacy of that claim, and only source from which RP can identify the legitimacy is the records available with him or records handed over to him by the personal guarantor.
So suppose even the claimant has not lost the claim. So can I make the adjustment? No.
Absolutely not, sir.
Okay.
So we had
Anjali, sorry for
queries,
extending the deadline.
But the time is not there. We had number of queries.
Sir, you have a number of queries. I have number of cases to discuss with you. I have a lot of things to have with you during the entire course, but there was an internet connectivity which has already consumed 20-25 minutes, and rest of the things is all about our deliberation, which has taken some extended time. But yes, I will be looking for some another opportunity wherein we can able to extend the deadline which we have already crossed at this moment. Some other faculty must be having her own agenda to initiate with
maybe request ICICI again to give another session for.
We'll do that. We'll also request on your behalf, because it is
yes.
Honor to be a part of this discussion, sir. Thank you very much. I enjoyed the interactions.
Thank you, sir.
Thanks a lot, sir.
Thank you, Vinit ji.
Thank you.
Excellent session.
Thank you very much, sir.
Thank you, Vinit sir, for such a nice and lovely presentation. Thank you very much for making the session very interactive.
Thank you very much. Thank you, the Institute.
Thank you very much.
Anjali ji, with this forum, I take this opportunity to, arrange for another program with Mr. Vinit sir, where questions has remained unanswered.
Sure, sir. We will plan some other session also.
Okay.
Thank you very much. Thank you very much.
Now there is lunch break till 3 p.m. Next session will resume at 3.
Madam, can we have the notes prepared by Vinit ji?
I will be sharing the same with the Institute, and the same will be circulated, sir.
Thank you very much, sir. Thank you.
Thank you, sir.
Thank you.
Thank you very much.
Thank you, sir.
दोबारा भी होगा
क्या होगा 3 बजे दूसरा सेशन है
That was so, empowering just to start the session. And I'm hoping everyone is there because I can't see any of you. Yes, thank you, sir. Thank you for switching on the video because it is really close to impossible to talk to the names of the people, and sometimes it's very refreshing to look at people who are actually there with you, reading the law, talking about it, does not give any pleasure to the reader. Thank you so very much, Purushottam sir, Rajkumar sir, Himanshu sir, Deepak sir. Thank you.
Madam,
So,
how many you are not seen? I mean,
oh, sorry. I myself switched off the camera. So, yeah. So it's good to see everyone there. So let me just share the screen, and I'm sure in the morning session, you all had a good time regarding the practical implication of the personal guarantor, the insolvency resolution part of the personal guarantor. And I can understand there must be more than 2,800 applications as per the last data available, and out of which almost half of them have been admitted, and insolvency resolution of the personal guarantors is going on at present. And in continuation of that, and as not a natural consequence thereof, the bankruptcy process starts, and we will see how just small difference between insolvency and bankruptcy of an individual, and thereafter the actual proper process of the bankruptcy and the practical problems that one might face. The views are my own views and should not be taken as a legal advice anyways. So I hope the screen is visible.
yes, it is.
Yeah. So about the insolvency resolution process of individuals, the IBBI latest last available newsletter also talks about it, but it rarely talks about the bankruptcy. And for the quarter ended March 24, the IBBI newsletter is talking about a total of 37 applications for commencement of bankruptcy, which have been filed, 1 by the debtor and 36 by the creditors, 1 before DRT Chennai and rest before different benches of the NCLT. This is the total information available in the IBBI newsletter itself. So if anyone is having any further data, because I have checked with ICSI, I have checked with IBBI, nobody is as yet maintaining any data on how many applications are filed, how people are working under this, what are the problems bankruptcy trustee is facing. And let me tell you some of the problems that I have myself observed while in one of the processes I have seen closely. So where we started for the individuals, I'm sure every one of you must be aware, and in the morning session, you must have been through this part, that how MCA just threw upon us something which we could not understand for many months. The individual insolvencies could not be started. I'm sure I'm talking about the personal guarantors only, because individual and partnership firms are not yet within the ambit of IBC. Thereafter, in Lalit Kumar Jain matter, the Supreme Court gave some light that personal guarantor is not discharged if the resolution plan is passed, even if the plan is passed. In Lakshmi Pat Surana, these are the important judgments for individual personal guarantor matters. NFC has a right to proceed against the CD and CG at the same time for the same amount. Thereafter, recently in November 2023, the entire clarity was given by the Honorable Supreme Court itself in Dilip v. Jwarjika case, which I'm sure everyone is aware about them. So I'm not going into detail of that, but it has clearly laid down the path for us to be followed, and it has clearly made it very, very clear in its point by point, section by section comparison with the CIRP, comparison with the individual insolvency process. Whatever is written in the code has been very clearly demonstrated over there that it is not against the Article 14. Natural justice is already there. It is inbuilt, and at the end, it also says that NCLT is bound to observe the principles of natural justice. So they do give some time before admitting the application under Section 100. But prior to that, at the time of initiation of the application, there is no such steps. There is no such language of the code which which is in violation of Article 14. So what are the laws applicable on the individual insolvency? That is part 3, that is insolvency resolution and bankruptcy of individuals and partnership firms. Out of this, fresh start has not yet started. Individual insolvency, yes, there is a flood of matters. 121 to 148 is bankruptcy order and its impact. And chapter 5 is 149 to 187 that talks about the administration and distribution of the estate. Thereafter, we have, I'm only concentrating on the bankruptcy part of it. So bankruptcy process for personal guarantors regulations, and then bankruptcy process rules I've taken care in my presentation today. So I am only talking about sections 121 till 187 and the bankruptcy process regulations and rules. There was another discrepancy regarding the DRT thing. Section 179 provides that AA for individuals is the jurisdiction lies with DRT, and that is the adjudicating authority. But no, that has not yet been started. Therefore, to clear the doubts, please go through the section 60 subsection 2 and 60 subsection 1 again, and therefore we lie under the ambit of NCLT only, and the matters for personal guarantors shall be dealt with by the NCLT, even if the corporate debtor matter is not going on. Even then, the NCLT is the adjudicating authority at present. So most important practical implication in the process, most important problem area is that it is personal. Like the name itself says, personal guarantors. It is a person, and we are getting into the estate of a person. We are getting into the expenses mode. We are getting into what he is doing day in, day out. How will he pay or not pay? How will he get discharged? How will we spend that 1 year with him? Because it is so close to him. We are getting into that personal zone of him. So that is, for me, that has been the most important and difficult task for all the bankruptcy trustees to start with, because the practices have not yet been settled. The practice have not yet been laid down. Precedents have not yet been made. Questions of law or fact have not yet been decided or taken to the AA. So this is a crucial time that we understand and we establish how we, proceed under this bankruptcy matters. So let us start through the meaning thereof. The bankruptcy starts when a person is legally declared incapable of paying their dues. And it is a process wherein an individual takes the help from the government to pay off his debts. The literal meaning of the word bankrupt is the rupture, the breaking down of his business. But we must remember that bankrupt is called bankrupt only when he is adjudged as such. So the definition also says the same thing. Bankrupt means a debtor who has been adjudged as bankrupt by a bankruptcy order. Each of the partners of a firm where bankruptcy order under Section 126 has been made against a firm, or any person adjudged as an undischarged insolvent by AA. That is, if the insolvent fails to get discharged under Section 92 or 119. So 92 is the result of the fresh start process, and 119 is after the insolvency resolution process. If the plan does not get through, if he is not able to give the plan or the plan fails. So in both those cases, the person shall be referred to as bankrupt. What are the differences between the insolvency versus bankruptcy of an individual we are talking? So insolvency is a state of economic distress that he is not able to pay. But bankruptcy is essentially a court order, which usually involves selling of his assets to pay off the debts, which he was not able to pay under insolvency. He was not capable of paying them himself. The individual can be insolvent without being a bankrupt. He can his position can be resolved through insolvency resolution process by successfully implementing the repayment plan if he has any, and if the creditors agree to that, and if that is successfully implemented. But being a bankrupt is a different state of economics altogether. It is the erasing of his liabilities, the debts, with whatever amount can be liquidated out of the sale of his assets, whatever can be realized out of the properties of that bankrupt. Insolvency can be temporary and can be corrected, but bankruptcy can severely damage his credit rating, and he may not be able to be the same borrower or a guarantor for many years to come. Bankruptcy cannot be without
Madam.
Yes.
Madam, I just wanted to know, is there anything which during the personal insolvency we can put a pressure on personal guarantor? Look, if you are not giving the reasonable plan acceptable to the COC, then you will be bankrupt. So what all the the right which he will be devoid of, he cannot do, and all these things, so that we can put a pressure. Look, if you are declared bankrupt, you will be declared bankrupt, then you may not be able to do these things, and
Yeah.
what all the
that is not called
consequences.
putting a pressure, that is called counseling. And if you are able to explain to him the disadvantages or the problems that he's going to face while being bankrupt, then it can lead to a successful resolution of his own insolvency. But if he's not interested, some people, they have some advisors behind them, some personal guarantors, they are being advised in a manner that clear off your, you do not possess any of your properties, you do not keep them in your name, and thereby you can get a clean sheet after bankruptcy. So this is how the mechanism is working right now. And I think after the bankruptcy cases are filed and admitted, thereafter, practically, when people will actually see this situation and when they will be called a discharged bankrupt or a bankrupt for complete 12 months, so he will face the consequences thereof, and thereafter, the practically people will understand the importance of the insolvency resolution, which is rather better position for himself than being a bankrupt. So it is.
And his voting right and everything might be suspended, or what?
Voting right in what?
Normal voting right, and in general parlance, let's say assembly election and.
Yes, they are. We'll see them through the restrictions on the bankrupt. He cannot be a director. He cannot be a partner. He has to send intimations to all those places. He cannot be appointed in a local authority or a political place. He cannot hold those positions in the society. So he will essentially have to, leave all those positions which he might have been enjoying during his life. And personal guarantors are generally well-off people. They carry certain name in the society, and when they have to inform all of them as part of the compliance of law, they need to intimate all of them. So at that time, he will realize that a repayment plan might have been a better option. But these days, right now, I don't think many of the even the advisors, so-called the advocates, the counselors, I should call them advisors, are advising them correctly, because it is a social stigma and it lasts for years to come. The process shall end in 12 months, but I don't think he'll be able to get those positions back in the society after those 12 months. But we'll see. We have not seen bankruptcy getting through as yet. So let us see.
So restriction of dividing his right is limited up to 12 months only. Thereafter, he can enjoy all the right.
Yes, but who will give him those positions thereafter? Do you consider our society is so generous and so kind? I don't think a person who will send an intimation stating that I have been declared bankrupt and I cannot hold this position any longer, and thereafter they will take him back with open arms. But let's see, because that is a situation yet to be seen.
There is no concept for forever bankrupt.
No, sir, nobody is forever bankrupt. In 12 months, he has to be given a discharge.
Okay.
Yeah.
Thank you.
So there are different stages of default. Some of them have been covered under insolvency, and that you must have covered in the morning. One is a defaulter when a default has occurred and no application for insolvency has been filed till that time. Thereafter, when application is filed but no order is there as yet, then he is a potential insolvent because he might be declared an insolvent. Once the insolvency application is admitted against him, he is called an insolvent. But in case the plan is submitted and plan is being implemented, he is an undischarged insolvent. If the repayment plan has failed, or in case no plan has been submitted, then he is called a bankrupt, but he has to be adjudged as such as a result of the insolvency resolution process. If the plan does not succeeds, then he is adjudged as a bankrupt.
Madam, has there any order passed for adjudge as bankrupt?
Yes, there are many. Like I told you initially, there are 37 of them which were admitted till March 31st, 2024. And thereafter, IBPI has not yet made a separate wing for this subject, you know. I tried finding it out today for getting a rough estimate of how many applications have been admitted under this. So they were not aware because a separate department has not yet been made for this purpose. Can you believe that? So bankruptcy trustees have been appointed. People are adjudged as bankrupt, but there is no data being maintained categorically as they have been doing for the other processes. Till March only the newsletter talks about 37 admitted cases, and thereafter I'm sure 35 more cases must have been admitted thereafter, because this has been going through such a speed. Even before this Deepak Jwarka case, some NCLTs did admit the insolvency resolution applications for the individuals. And I'm sure in 2 years or 1.5 year, 2 years time, they must have been coming to an end. And as a result of those applications only, some people might have been declared adjudged as bankrupt.
If you could share some of the citation if you come across.
Yes, I have many of them. What I'll do is at the end of the presentation, I'll have to amend my this thing. I'll add a slide. I'll add those orders, NCLT orders where the bankrupts have been admitted. There are so many of them. There are many of them, but you can't get them in the IBPI website. Also, it is difficult finding because bankruptcy is a common word and it appears in all the orders. So you cannot just write the subject matter over there. So a search is difficult.
Yeah, I tried to search it, but I didn't come across any.
Yeah, I'll share in the presentation itself. I'll share.
Harmeet ji, good afternoon.
Good afternoon, Ajay sir.
Just wanted to know, is there any format like CRP 3, CRP 4 like that? Is there any format for this?
No sir, no.
No,
अभी तो
nothing.
voluntary liquidation के अब जाके आए हैं. आप क्या expect कर रहे होगे?
Okay.
They don't have a department
So,
only for this purpose. They
कुछ
only
भी
have 3 departments as yet working on the 3 processes: CRP, liquidation, and voluntary liquidation.
RP has to only intimate by email. That's it.
Yes. There are certain forms which I have included in the presentation. You will just see on the next slide.
Okay,
There are
thank
certain
you.
forms available, but not all of them. Right
Okay.
now, the work is being done via emails only. And only a few days ago, we were working in the voluntary liquidation. Also, we were working on the emails only. There were no forms set for us. So I think this shall not be a slow process, and they might be working on something and we might get to see something, but till now, nothing.
Okay, thank
So
you.
that is the most important practical difficulty, that there are no formats, there are no procedures set down as yet, but people are inventing and they are working on it. In the bankruptcy, there are the stages. One is the undischarged bankrupt. That means a bankrupt who has not yet received the discharge order. And after the discharge order under Section 138, important factor is that he is released from all the bankruptcy debt. So that is very interesting. I find it rather unreasonable, and but let us see from the individual perspective. If he is getting some relief, he is not able to pay, and he is getting some relief after 12 months. So let's see how it fares in actual times. So the process starts with the application. Application can be made by creditor or the debtor. In case debtor is a firm, then application can be made by any of its partners. Within 3 months of the order, under Section 100, 115 or 118, What are those sections? Let us just see them. 100 is the creditor is entitled to file the application wherein application for IRP is rejected by AA. Then the application can be filed for bankruptcy. Order by the AA recording rejection of the plan. Then both the debtor and the creditor are entitled to apply. Order of the AA on premature ending of the repayment plan. Then debtor or the creditor whose claims have not been fully satisfied, they are entitled to apply for the bankruptcy. So the applicant can propose the name of an insolvency professional to act as bankruptcy trustee, but it is not mandatory for any of them. Then section 123 subsection 2 talks about the application to be accompanied by which documents? A statement by the creditor having the right to enforce the security that he shall, in the event of a bankruptcy order being made, give up. If he is ready to give up his security for the benefit of all the creditors, that is a similar right of relinquishment. And second, by a statement by the creditor stating that when the application is only in respect of unsecured part of the debt, so thereafter an estimate of the unsecured part of debt also. So secured and unsecured both he has to declare, and that is to be given along with the application. Now here we have a concept of interim moratorium because I found them interesting to be read together. Therefore, I have kept them together. There is no interlinkage amongst them, but it is only for my own understanding that I keep them together. So one is the moratorium that commences once the application is filed. Immediately at that time, a moratorium starts, which terminates on the bankruptcy commencement date. And on the bankruptcy commencement date under section 128, when the order for bankruptcy order is passed, then a moratorium starts. So I have only taken out only those important points which have some impact on our working, and the other points I've not copied from the sections, and you can definitely go back to the complete code for that. Once the application is filed, no action can be taken against the debtor in respect of his debts. No creditor can initiate legal action against the properties in respect of any of the debts of the debtor. And when a bankruptcy order is passed under section 126, when it is admitted, when a bankruptcy trustee is appointed and all that has actually happened, then the final moratorium is applied. And subject to the provisions of subsection 2, which I have not copied here, a creditor shall not initiate any action against the property of bankrupt in respect of a debt or commence any suit or other legal proceeding except with the leave of AA and on such terms as the AA may impose. Another important aspect here about the disposing of the property. Section 158 talks about any disposition of the property made by debtor during the period between the date of filing of the application and commencement shall be void. So this is very important, which was not clear under section 124. It was not clearly written over there, but yes, there is a prohibition on disposing of any property by the debtor himself during the period when the application is filed. So one should encourage the bankers, the other creditors to file the applications at the earliest so that you can save some property, because otherwise he has he'll just keep selling all of them and bankers won't get anything out of the realization thereof. This is the entire process summed up here. So on the face of it, it looks so easy, just like a liquidation process. The application is filed, interim moratorium starts, the bankruptcy trustee is nominated, bankruptcy order is made under 126. Within 10 days, within 7 days, the bankrupt has to submit a statement of financial position, his own financial position to the bankruptcy trustee. And within 10 days, the notice or public notice to the creditors and public notice in the newspaper have to be published for inviting claims from the creditors. Thereafter, within 7 days, the creditors have to register their claims with the BT. The BT shall prepare a list of creditors, will summon a notice of, will send a notice and conduct a meeting, 1 meeting, 2 meetings, whatever is required. Then completion of the administration and distribution of the estate. Then report is filed, and thereafter his report is approved, and whether bankruptcy trustee shall be determination of whether bankruptcy trustee shall be released. So determination shall be discharged, and thereafter the bankruptcy trustee is released. So this is not so simple. This is just for an illustration with minimum steps. So let us see what happens when an application is made. If you can just give me 1 second, because I'm finding my AC to be too cold. Just give me just 1 second. Yeah, sorry. So when an application
You are not audible.
Ma'am, ma'am, better you switch off your video so that voice.
Is this better?
Yeah, now you are audible.
Is this okay?
Ma'am, it's okay, but presentation is not there.
Yes, I'm just sharing. Visible?
Yes.
Now,
Yeah, so there was some connection issue also, yeah. So if the IP name is proposed in the application, then he shall be appointed after getting a confirmation from IBBR. IBBR shall confirm within 10 days. The order is passed under section 126. And then the impact of the order we'll just see on the next slide. AA shall, within 7 days of passing the order, provide the following documents to the bankrupt creditor: the copy of the application filed and the copy of the order, so that the bankrupt as well as the creditor both are aware about the application being admitted. Okay. The validity of the order shall continue. The order shall continue to have an impact till the debtor is discharged under section 138. The effect of the order is that the estate of the bankrupt shall vest in the BT. The creditors shall not initiate any action against the property of the bankrupt. They shall not commence any suit or other legal proceedings except with the leave of AA. The secured creditor's rights are not affected if they inform as such. So I found some practical difficulty for the BT when there is a SARFAESI action going on. If creditors do not inform you on time, if you are not aware about the properties and the actions which were already continuing, so in that case, the creditors need to be informed about the prohibitions under section 128, and they need to cooperate, and they need to understand and provide all the information, etc., to the BT on time. Then the bankrupt has to give a statement of financial position to the BT within 7 days of the bankruptcy commencement. हमें ये पता ही है, we are all facing this since inception. CIRP हो, liquidation हो, voluntary हो, कुछ भी हो, in all the cases, promoter directors do not cooperate. They do not give the complete information. It is not received within the time stipulated in the act or the regulations. So that is a one practical difficulty here. Another major difficulty is about finding out information about an individual. An individual's information is generally not available on the internet as such. It is not updated in the manner it should be, because generally you get the LinkedIn profiles which are made by them. You get the news articles which are written for them. So general information apart from the court orders, etc., are not available so that you can assess information and details about their assets and properties, etc. But I have listed out some of the sources from which some information about the debtors, promoters, or whosoever bankrupt is there. You can find that out from MCA data. The balance sheets of not only his own company, but the related companies or the LLPs or other firms, etc., which are available. Stock exchanges in case there is a listed company as a CD. Form DIR2. One has to carry out some inspection on the MCA. You can find out his appointment or consent forms. Therein, you will get all the details about his person. Most of the information which he will be providing you over the next 15-20 days is available under DIR2. Income tax, GST login, and repayment plan. You will only get that much information that he has filed. I'm sure they do not file information. They do not file their returns, etc., because they are aware that that information may be used against them. So they they do not disclose about their businesses. They do not disclose about the place of businesses. They start removing the information in whatever manner they can. So they start preparing themselves well. And
So
we are given.
Madam, income tax GST login, and then side में आपने लिखा है repayment plan. What exactly that mean?
No. They are different points. I have just clubbed them together. Income tax and GST login. Once the bankrupt will provide to you, then only you will be able to enter into that, and you will find whatever information if there is something available for the recent years. Repayment plan is the one which the bankrupt himself gave when he was his insolvency resolution process was going on. You must have seen that in the morning session.
Yes.
Hana, this is that repayment plan. So he has already given some information. So you will take that from the RP who has taken care of his individual insolvency. Even the Data Protection Act, that is not yet into picture, but yes, whenever it will come into picture, the personal data that is made or caused to be made publicly available by the concerned person to whom such data relates, that is allowed to us to, access. And thereafter, one more clause is there, any other person who is under obligation under any law for the time being in force. So he will be covered under both these situations. Whatever data is available in the public domain, we are assessing that. And we are also he is also under an obligation to provide all such data to us. So personal data breach is not happening over here. And if anyone, any guarantor, etc., comes out with those pleas, you can always inform them.
So I in the capacity of BT, so what all information I am entitled to receive from IP?
From
the type of
IP.
repayment plan, yes.
IP has simply, a discretion to provide you the information, and the order, etc., is available on NCLT. You can always get that. The repayment plan you will get from him, and whatever information he must have inspected or collected during his process, his resolution process, he must give that to you.
Okay.
Yeah. So persons who have to extend cooperation, this is similar to the CIRP and liquidation. The bankrupt himself, the creditors, the employees and workmen of the bankrupt, the partners of the bankrupt, the auditors, they are all obliged to give you such information, whatever information they are possessing. Even the people appointed by you, when they are, for example, valuers are carrying out physical inspection, or auditors have got to know some information from the previous auditor or something. So they need to inform to you. They are under an obligation to share all the information with you. The RP or the previous BT, in case that is the case of replacement. The IRP, RP or liquidator in case of the CD of which the guarantor is the guarantor. Or any other person who has possession of any of the properties of the bankrupt, or any other person connected or relevant to the bankruptcy process. So they are all under obligation under law, under regulation 12. So हमारा 19(2) यहाँ पे 12(2) बन जाता है, 12(3) बन जाता है. 12(2) is BT shall record and maintain the particulars of consultation he had with the persons mentioned under sub-regulation 1, which we hardly maintain. And 12(3) is where the BT, after making all the reasonable effort, fails to obtain any information, then he may make an application to AA for directions. Another important section is relevant to this subject is if any of the creditors or bankers or agent or any person is having possession of any property, books, papers, titles, or other record which BT is required to take possession of for the purposes of bankruptcy process, he shall deliver the said property and documents to the BT. So you can always start writing to the concerned persons, the list of which you can get from the RP maybe, or from the bankrupt himself, or you can find them out through the last available balance sheet or whichever way. Then you can start writing to them and you can take the information from them on the basis of section 156, which is having larger force than I think regulation 12.
Madam, under this, any other person includes property registrar and all the other government authority?
Connected or relevant to the bankruptcy process, in case you are not getting information directly from these direct connections, then yes, you can, as a safety, as a precaution, or as a chance, taking a chance, you can write to them. But I'm not sure whether they are in a mood to cooperate to even the direct linkages. I don't think they'll be helping you initially when they are not aware about the bankruptcy process. People are generally not aware about this process right now. अभी तो CIRP समझ में आने में time लगा government authorities को. So you can write to them. Let's see how they react. So the public notice, the section 130 says within 10 days from the bankruptcy commencement, the AA shall send notices to the creditors. तो यहाँ पे थोड़ा लिखने में गलती हो गया इनसे, and thereafter they corrected it in the rules कि AA shall issue notice in form C, but AA may direct the BT to issue the notice. And you know what is happening? AA is not writing in the order that BT has to issue such notices, and AA itself is not issuing such notices. So आप ये समझ लीजिए, the BT has to send those notices to the creditors under subsection 1, and he has to issue public notice inviting the claims from creditors in the newspaper in the manner provided over there, in the form provided in the rules. But he has to do it himself, whether the order says or not. Under section 131, the claims have to be registered within 7 days. There is a list of claims and creditors which must have been made at the time of insolvency resolution. So you will get that from the RP. If new claims come at this stage, then you will need to check them, verify them, because that will be a challenge. In the absence of any information, it will be very difficult. No treatment is suggested for the belated claims. Like in liquidation, we have that section 42 ka appeal. The creditors go and get the claims admitted. So here there is no treatment suggested for such claims. Under section 132, a BT ka काम start हो गया है. So let us see what problems he might be facing in the future, after the start of the process. He shall, within 14 days from the bankruptcy commencement date, prepare a list of creditors on the basis of information disclosed by the bankrupt in the application for bankruptcy filed by himself, अगर उसने खुद से file की थी being a debtor, and the statement of affairs filed under 125, which he must have filed to you. But both these things may or may not be available to you within 14 days. So that will be a challenge. Thereafter, the claims received by the bankruptcy trustee under subsection 2 of section 130. So those also you will consider, and with that help, you will finalize a list of creditors. Regulation 20 also talks about the BT shall report the establishment of committee. You will establish a committee. The formation or constitution of COC is called establishment here. And you will file that with AA within 3 days from the COC meeting under subsection 1 of section 134. So we'll see that 134 later. The PT shall modify the list of creditors and composition of the committee on the basis of proofs received under section 171. Now go to the section 171, which is highly misplaced, and this is not at the correct place, because you are inviting, you are giving notices to the creditors to submit proof of debt within 14 days of preparing your own list under section 132. Thereafter, people are submitting proofs, and thereafter you shall be modifying the list, right? So the list of creditors and any modification to the committee mentioned in the subregulation 3 shall be filed with AA within 15 days from the last date of receipt of proof of debts under intimation to the creditors. So you need to file the list of creditors. You need to file the constitution of the committee with the AA. The list of creditors has to be filed within 15 days from the last date of receipt of proof of debt. So proof of debt is being asked for under section 171, right? And the committee is established, meeting has happened, and thereafter in 3 days, you are filing the formation of the committee report with the AA. So the timelines are all haywire. All corrections are need to be done. I think while writing these regulations and while writing this portion part 3 of the IBC, much mind has not been applied, and practically when we are going through these and the language of these sections and the regulations, personally I felt I found them so difficult, and every stage of it I need to understand from one or the other colleague of mine, so whether my understanding is correct on the subject or not, because they are so improperly drafted. Then section 128 subsection 2 provides, ISCA proviso says that no secured creditor shall be entitled to any interest in respect of his debt after the BCD if he does not take any action to realize his security within 30 days from the said date. So this is a clarity that they have given under section 171 subsection 8 also. And this is such a nice step for us, because when BT serves a notice on any person or a creditor, and he does not file a proof of security within 30 days after the date 132, after the date under section 132 of serving of the notice, the BT may, with the leave of AA, sell or dispose of any property that was subject to the security free of that security. So that is a clarity given under regulation as well as section, which was missing in the liquidation process earlier. Now, section 133, summoning meeting of COC. Now there is a major flaw here. Again, I find that to be a flaw. Within 21 days from the bankruptcy commencement date, the BT shall issue a notice. And thereafter, notice shall state the date of the meeting of the creditor, which shall not be later than 21 days. So 21 days from the start of the commencement of the process, he shall issue a notice, or 21 days shall be the date of the meeting. That again needs a correction. The regulation is supportive. It says a meeting of creditor committee shall be convened by giving a notice of 7 days or such other notice as decided by the committee, which shall not be less than 48 hours. Section 134 talks about the conduct of meeting. BT is called convener. He is not the chairman here. He is called convener, and he shall convene the meeting, constitute the COC. He shall decide the quorum. Surprisingly, he shall decide the quorum and prepare the minutes. And there is a proxy form, specially given under regulation 26. It says the creditor shall deliver form B duly completed to the BT at least 24 hours prior to the meeting of committee. That is a form for proxy. Voting rights, voting with liquidated debt only. It excludes the related parties. They are not allowed to vote. Regulation 24 says the voting share of secured creditor shall be in proportion to the unsecured part of debt if it has opted to enforce its security interest, and if it has relinquished, then the entire debt. The voting share of the secured creditors who has opted to relinquish, then the amount of debt that has been relinquished shall be considered for voting. Regulation 25 says that BT shall take a vote of creditors present in the meeting. Only those who are present in the meeting shall vote on any item listed for voting after discussion, and any decision of the committee shall require more than 51% of the voting share of the creditors who voted. So till now, life is easy. I don't think this will remain the same, and they'll also try and change this. Section 136 talks about the distribution of estate in accordance with Chapter 5. Regulation 8 says that within 90 days of the commencement, the BT shall submit preliminary report. Regulation 10 talks about filing of progress report within 15 days from the end of each quarter. Section 137 talks about convening of meeting on completion of the administration and distribution in accordance with Chapter 5. Chapter 5 in itself has certain sections which should have been here, but I don't know why and how the sections have been placed. So we will go through some important sections in Chapter 5 hereafter to decide or approve the release of BT under Section 148. Discharge order, BT shall apply to the AA for discharge order for the bankrupt on the expiry of 1 year from the bankruptcy date. or within 7 days of the approval of COC of the completion of administration process and distribution of the estates of the bankrupt under section 137, if the approval is prior to period of 1 year mentioned above. So whichever is earlier, that means if 1 year happens, then 1 year, even if the approval is not given by the COC till that time, administration is not complete by that time, even then the BT shall be, the bankrupt shall be the section 138. Approved. So this debt is not considered to be discharged, even if the repayment plan is approved under insolvency, or the person is, the bankrupt is discharged under the bankruptcy process. This debt remains to be paid, and this is excluded from those plans. Section 79, subsection 15, it talks about maintenance to be paid to any person under any law, because that person's legal right is to get the maintenance from this person, so that we cannot defray. We will have to continue with this. Liability with respect to a student loan, that has to be repaid. Damages for negligence, breach of statutory obligation, etc. Those penalties, fine imposed by any court or tribunal, these are not discharged. Any other debt as may be prescribed, which has not yet been prescribed by any authority. Effect of discharge. Bankrupt is released from all the bankruptcy debt, except the excluded debt we have just seen, and the debt incurred by fraud or breach of trust, etc. But the BT shall continue to function, because chapter 4 and 5 of part 3, which talk about the bankruptcy process, which is our process, and chapter 5, which is administration, that is also we have to do all that. So that will continue. Disqualification of bankrupt. So how and what all areas are restricting bankrupt after the bankruptcy order is passed till the discharge or recall of the bankruptcy order? He cannot be appointed as a trustee or representative of a trust, estate, or settlement. He cannot be appointed as a public servant. He cannot be elected to any public office. He cannot be elected or vote as a member of a local authority. So important here is the practical problem here will arise as soon as the order is passed. This information has to go to all these authorities wherever he is holding such positions, and for the next 12 months or till the time the order is recalled, in case that the case that is the case. So who shall send the intimation to the said authorities, and who shall make sure that the compliances are being made by the bankrupt? Because this is a law applicable to us, we have to make sure. So we shall start writing, or shall we just ask the bankrupt to write and give us a proof of that intimation, or what? There are certain restrictions imposed in the section 141, apart from the disqualifications that have been referred under 140. So bankruptcy order also attracts the following restrictions. It says he cannot act as a director or promoter. He cannot create or charge his or her debt. He cannot take further debt without approval of the bankruptcy trustee. He must inform the business partner of ongoing bankruptcy. He must inform the party before entering any transaction. He cannot maintain legal proceedings with respect to bankruptcy debts. He cannot travel overseas. He cannot be a member of a professional body. So these restrictions have been imposed. We understand they are quite elaborate and they are extensive. But the problem here is, again, I have found a problem to send intimations, because he may not have given me the entire information of wherever he is a promoter or director. where there shall be any capacity to take any further debt. They say he cannot create a charge or take any further debt. He shall inform his business partners and every party prior to any commercial transaction about the process going on. So how will you ensure the compliance thereof? In case he is roaming free, he is entering into commercial transactions without disclosing the fact that there is a bankruptcy process going on. And in that process, he sells some of his property or parts of it with the title or interest in some of the assets or something. So the beneficiary, the third party who is not aware of the process and he buys that in good faith, so he will get a clear title to this, and that is the major flaw in this process. Prior to entering into a financial or commercial transaction of such value, that is 1 lakh, either individually or jointly inform all the parties involved in such transaction that he is undergoing a bankruptcy process. So okay, and here that is 1 lakh that we have understood. Without the prior sanction of AA, be incompetent to maintain any legal action or proceeding. So he shall go to the AA. He shall ask for a leave for filing cases against his own debts. So I don't think AA will be interested in giving him any such permissions. He shall not travel overseas without AA permission. So do you think the compliance of travel norms can be maintained by a BT? How will you do that? Will you seize his passport or do what? Or will you write to the authorities that he should not be given any visas or he should not be allowed to travel? Or how the compliance of this part shall be made? Others were related to financial transactions or his being present as a director or somewhere. But how will you stop him traveling overseas? So compliance is very difficult. Practically, this shall pose a problem unless you just seize his passport, which is, I think, again, a personal problem. Section 142 talks about modification or recall of an order. Recall or modification can be made on an application or by or suo motu if there is an apparent error in the application or the admission, if both the debt and expenses are paid or secured, and it shall be binding on all the parties involved. Fee of the BT, first 6 months, next 3 months, and next 3 months thereafter the slab shall be used. This is similar to the liquidation one. Again, the regulation is also same. Fee in proportion to the value of the estate and has to be paid from the distribution of estate as per section 178. 178 is similar to section 53. 145 talks about the replacement of BT, which can be by the COC with 75% of votes. 146 talks about resignation. If he intends to cease to practice as IP or there is a conflict of interest or there is change in personal circumstances. Vacancy in the BT office for reasons other than replacement or resignation. Release of the BT can be made on the appointment of a new BT and on completion of the administration of the process, which is again not limited to 12 months. So this is a fee schedule. This is given in Schedule 1, the fee of bankruptcy trustee. In case the fees is not fixed by the COC, then it shall be paid in this manner. The functions of the BT are, now most important function, first function is to investigate the affairs of the bankrupt. And my presentation started only with this point, and how will you investigate the affairs of an individual? In India, generally, most of the information given in the public domain is made by somebody, and it is not based on actual facts unless it is a corporate.
Harmeet, there is no fees criteria during this insolvency resolution process of this personal guarantor?
That is fixed with the help of the COC, right? So COC has to fix that.
No, IBBI has not yet fixed.
No, that is not that. So important functions, 3 important functions: investigate the affairs of the bankrupt, realize the estate, sell off the assets, and distribute, right? So the information about the affairs or the assets of the bankrupt are not easily available. Exact asset base is difficult to identify, and the COC has to bear the cost of investigating agency if in case you you propose some hiring of some agency for this purpose, because there are certain, they call it, which agency? They do have such agencies on their panel. They use them for recovering or finding out that particular name is missing from my mind. So they do have such agencies.
Detective
Yeah.
agency.
Sorry, detective agencies. Yes. So that was such a common name. Sorry. So you can ask for your COC, ask for appointment of one of such agencies, because beyond, I don't think without that agency on board, you can investigate the affairs properly and you can do justice to the creditors. Bankrupt is anyways saved because he has given a repayment plan. He has given such declarations everywhere that he has this much to pay. Then the duty of the bankrupt is to assist the BT at all times by giving information, by attending him when required, by giving notice to the BT of any acquisition or devolution of any property or increase in the income within 7 days of happening of that. Regulation 28 details about this. It says that after a notice is given by the bankrupt under section 150, he shall not part with any increase in his income or dispose of any property acquired without the prior permission of AA. If the, and this is very funny, sub-regulation 2, this is so funny. If the bankrupt disposes a property before giving the notice under subsection 2 of section 150, he shall within 7 days from such disposal disclose to the BT the relevant details of the person to whom the property has been transferred, and shall also provide any other information which may be necessary to enable BT to trace the property. तो वो पहले से नहीं बताएगा, वो बेचने के बाद बताएगा कि जाओ अब ढूंढ लो जिसको ढूंढना है. तो sold the property. So this, I found it so funny. In practical parlance, it is actually not possible, and if it is so happening, so BT shall, what shall BT do? BT bhagna shuru
BT shall
karega
apply
जैसे.
for cancellation of sale deed, which will take at least 3 years. And
I
then
don't
after
think
this
BT
will
can
go-
do, BT shall do that, because there is also a provision na, the buyer who has bought it in good faith, and वो सब clauses भी तो आ जाते हैं आपके contract वाले, without notice of the bankruptcy. तो अगर bankrupt इतना ही cooperative हो, तो वो पहले सब regulation 1 में आपको notice क्यों नहीं दे देता है that I'm going to sell? वो process क्यों नहीं follow करता है? And thereafter you have given a provision specially for him. If he has forgotten to inform you, then he will sell, and thereafter in 7 days he will give you idea कि वो कहाँ गई है, जाके ढूंढ ले, which may be necessary to enable the BT to trace the property and recover it. मैंने बेच दी, now you recover. Any expense incurred by the BT in bringing back any amount or acquiring title to that property shall form part of bankruptcy process cost. Yes.
Is the bankrupt authorized to dispose of the asset during this process?
Yes, that is his job.
Oh.
That is what he has to do, sir. There are 3 major functions: investigate the affairs, realize the property, sell the properties, distribute the proceeds.
No, that is for BT, but here is mentioned bankrupt. Bankrupt, the debtor is authorized to sell the property.
Yes.
No. How can debtor, the bankrupt person, how can he sell the property without consent? He can just suppress, he can suppress all these things. Behind the BT, he can sell it.
Yes. But section 150 says that he shall give a notice to the BT of any acquisition or devolution of property within 7 days of that. And regulation talks about a scenario when a notice is given by the bankrupt to the BT. He shall not part with any increase in income or dispose of any property without the prior permission of AA. So he shall simply go to A, take permission, and I don't know what is BT doing there. Rights of the BT are to hold the property, to make contract, to sue and be sued. I understand that 151 is also the duties of the BT only, because these do not sound to me as the rights, but yes, they are called the rights: to hold the property, to make contracts, to sue, to enter into engagement, to employ persons, and to execute power of attorney, etc. in the name of the BT bankrupt. General powers of the BT: while discharging these functions, he may sell any part of the estate. He may prove, rank, claim, or draw dividend in respect of such debts. He can exercise the right of redemption of any pledge, etc. He can exercise right of transfer of any securities or transferable property. What time we shall take a break? Anjali?
Take break.
Shall we?
Yeah, you can. I think there is no issue.
Acha. Anjali, we take a break of 15 minutes. Is that okay?
Fine.
Yeah, thank you. Yeah. So we meet in 15 minutes. relied upon under
Okay,
bankruptcy
market.
and yeah. So realizable is what is readily liquidated in the market. And it is not likely that the bankrupt, who is a personal guarantor, will have a dwelling unit which is of this value. So most of them are having lavish houses. So how will you tell him to vacate the house, give it to you, and you will just buy, give him 20 lakh worth of house to him for those 12 months? Or what will you do? So I don't know how practically this shall be possible and how the bankruptcy trustees are doing this, going through this. So I would like to invite comments from any bankruptcy trustees if we are having anyone, because here I have listed out so many of problems that I think we will face in this. But what is the solution? If any one of you have gone through this situation?
In Metro City, you cannot find in even a single room on
Yeah.
the cost of 20 lakh rupees.
Yes. And how will you tell that person? So 20 lakh is is an amount. How will you tell him that you vacate your house and go to some 1 room, 2 room flat, or what? How will you do this? So anybody is having any suggestions on this? I only found one solution, that I will ask him to vacate. I will sell that, realize that money, and give him 20 lakh for buying another dwelling unit for himself and his family. So,
if he is
or
not able to buy, then he will
no,
stay
he
on the
will live
roadside.
in his spouse's house. आपको ये नहीं लगता है कि उसने अपने स्पाउस के नाम में पहले ट्रांसफर कर लिए होंगे सारे हाउसेस एंड ऑल प्रॉपर्टीज?
सारे इतने क्लेवर नहीं होते, लेकिन हाँ ठीक है.
He may go for a rental house.
And who will bear the expenses? Up to 1 lakh you will be giving to him.
So you are giving 20 lakhs to him, no?
No, 20 lakh is one time for one property value. That is the value of one property.
So by the time your work will also over, let him do whatever he wants to do.
अच्छा, हाँ, ये भी बात ठीक है. तो ये भी अच्छा solution है. उसकी वाइफ या उसके हस्बैंड के पास भी होगा कोई घर रहने के लिए. आई एम श्योर. मैं तो बोलूंगी उसी में रोज आके.
If BT is so kind, then he can also offer, he or she.
What will he offer? What will be?
He can also donate or offer his house also.
Sir, how?
BT.
How, sir? BTs are only professionals. They are not guarantors. They are not at their level. They will never do
They
that.
have to shift to a, semi-urban kind of a place. Now it is up to them to decide. Basically, we have to perform our duty and we have to ask them to vacate.
We will have to tell them that this is the law. We need to sell your house eventually. So you will have to vacate this and hand it over to us. Because on the date of passing of the order, property vests in you. Vests in the BT.
Madam, small doubt. What happens if the property is jointly owned by the guarantor and his wife?
Yes. So he will not be able to take
Happens if
possession.
the value is more than 20 lakhs.
Yeah, of course, the value will be more than 20 lakhs only. But I have written that in my practical challenges. And I understand that in the jointly owned property, BT cannot take interest and he cannot have that vested in himself. Or he will get that value.
What will happen if this bankrupt person is residing in rented accommodation and his house is also let out? Then?
Let out house will become property of the BT.
But can BT ask to vacate?
Yes. Why not? It is his duty and his power.
It will take long time, because if he refuse, the tenant refused to vacate the house, then legal battle will take 3 years, 4 years.
Yes, so that is a practical difficulty one will face. The processes have just started and I'm just waiting for cases to be filed, and there have not been any cases filed for that matter for any question of law or fact with the NCLTs till date. So it will be very interesting to see how the rented house or jointly owned properties and all those challenges will be met, because it is not an easy task to tell a person of a guarantor level person, director, promoter, guarantor, you just tell them to vacate their house. And so these are some challenges which I thought about, that it may be owned jointly or owned by the spouse, or the debtor has a right to stay.
BT will have to be very merciless.
He will have to be an individual insolvency बोलते तो है ना हम don't take it personally, but it is actually so personal. So one regulation 30 talks about valuation, which the code does not provide for, but the regulation says that the BT shall appoint a registered valuer to value the assets, which may or may not form part of the bankrupt's estate. I don't know why, what does that mean, which may or may not form part of the estate, when he is of the opinion that it is necessary or when a resolution to that effect has been passed by the committee. So BT has immense power here. He can get the assets valued, which may or may not form part of the estate, and he may value them from the perspective of this dwelling unit or ornaments, etc. From this perspective also, for the purpose of excluding certain assets and including certain assets in the bankrupt estate. So he will get them valued if he feels that is necessary. The RV appointed under subregulation 1 shall submit to the BT the estimates of the realizable value of the asset computed in accordance with internationally accepted valuation standards after physical verification of the assets of the bankrupt. The BT may appoint an additional registered valuer by valuing the assets of the bankrupt if required in the circumstances of the case, who shall independently submit its estimate as per subregulation 2. In the event an additional registered valuer is appointed under subregulation 3, the average of the estimates received from both will be considered to be the value of the assets. So this is a huge power given to the BT, but this is not covered under the code. This is only coming via regulations. Further, section 158 talks about restriction on disposition of the property. I also covered it earlier. Any transfer shall be considered as void if bankruptcy application filing day, if it is happening between the filing of bankruptcy application till the commencement of application, unless it is carried out in good faith for proper consideration and value and without the notice to the buyer. The buyer was not aware about the continuation of the initiation of the bankruptcy application. Section 159, after acquired property. Now, what is after acquired property? Any property acquired by or which devolves upon the bankrupt after bankruptcy commencement date till his discharge. The PT can claim the same within 15 days of the fact coming to his knowledge. This shall not include the excluded assets or property acquired after the discharge order is passed. BT cannot claim from any other person who has acquired any right over the after acquired property in good faith for a value and without notice of the bankruptcy. So these all clauses give huge potential scope for disposition also. 160 talks about the onerous property, any unprofitable contract, any unsaleable or not readily saleable property or future claim. The BT may disclaim after notice to the bankrupt with COC permission. And 61 talks about the notice of disclaims. 62 is about disclaimer of leasehold property. 63 is challenge against disclaimed property. So these we will go into these sections as and when we will need to, because these are not the regular process sections. Now, this is very interesting. In the resolution process, there is no mention of coup-fait transactions, but in the bankruptcy process, the BT has rights which are manifold of the RP in case of the individual insolvency processes. So here he will find out the undervalued transactions, and there is a long list. If a transaction falls under any of the following heads, that is, if it is given to any person as a gift, I have given gift to anybody, shall be considered an undervalued transaction. No consideration received. In consideration of marriage, any amount is given, significantly lower in value than the actual transaction, the actual rates which are prevailing. So these all transactions shall immediately be considered as undervalued transactions. What else? Any transaction with any related party during preceding 2 years of the bankruptcy commencement date shall be deemed to be undervalued immediately. Undervalued transactions during the 2 years preceding filing of the application and should have caused bankruptcy to be triggered. Those are also covered under undervalued transactions. Preference transactions are covered for 6 months preceding the filing of the application with unrelated parties and 2 years with the related parties. And these should have caused the bankruptcy to be triggered. A bankrupt shall be deemed to have entered into a transaction giving preference to one person if person who is a creditor or surety or guarantor for any debt of a bankrupt, if that transaction puts that person in a better position otherwise in the distribution of estate. Extortionate credit transactions are involving provision of credit to the bankrupt on exorbitant or unconscionable terms as per the contract law, and transaction must have happened during the 2 years preceding BCT. So some sections talk about filing the application, that is the trigger date, and some sections talk about bankruptcy commencement date as the relevant date. 168 talks about the obligation under contract by the bankrupt with a person before bankruptcy commencement. Any party can apply for discharging obligations and demand damages or compensation which can become a bankruptcy debt, provided that person was not having knowledge of initiation of the bankruptcy application. 169 is the continuation of proceedings on debts. They shall proceed as if the bankrupt is alive. Administration of estate of the deceased bankrupt kaise hoga? All the provisions of chapter 5 shall continue as far as they are applicable to the estate of a as they are applicable, they shall apply to the administration of estate of a deceased bankrupt also. Only that reasonable, proper funeral and testamentary expenses shall become part of the bankruptcy cost and shall be not the bankruptcy cost. They shall be they shall become the bankruptcy debt and they shall rank pari passu with the secured creditors. So they shall be paid immediately after on the second number after the bankruptcy process costs. 173 talks about mutual set-off, which is allowed similar to the liquidation regulations and process. 174 talks about interim dividend. If enough funds are available, then interim dividend can be given to the creditors. 175 is a distribution of property. It can be done for a property in existing form also if it is not readily sellable. 176 talks about the final dividend after realizing entire estate, after selling off all the property, after disposing of all the assets, or as much as could be realized. Bankruptcy trustee shall give notice for final dividend on a particular date. Now comes our section 53. It talks about the hierarchy. First, the cost and expenses of BT shall be paid in full. Thereafter, the secured creditor debts and workmen dues of the last 24 months from the BCD, employees dues of 12 months from the BCD, government dues of 2 years from the bankruptcy commencement, and thereafter all other debts, including the unsecured debts. Now here something is very interesting. If any surplus is left, then it is not given to the bankrupt himself. Then an interest during the bankruptcy shall be paid, and interest payments under subsection 5 shall rank equally irrespective of the nature of the debt. So the interest shall be paid to all of the debtor, all of the creditors, irrespective of their rank. So this is something which is quite different from section 53. Otherwise, we are close to that. In terms of hierarchy, we are quite close to that section. Offenses and penalties. Section 184 talks about false information to the RP by creditor or debtor. So this is applicable to both insolvency resolution process as well as the bankruptcy process. So if any false information is given by the creditor or the debtor to the RP, so imprisonment up to 1 year and fine up to 5 lakh, imprisonment up to 2 years for creditor and fine up to 5 lakh or 3 times if voting dishonestly on the repayment plan. Contravention by IP deliberately, then imprisonment up to 6 months and $1 to 5 lakh or fine or both. False information, concealment, etc. by the bankrupt. So 186 is the section जिससे आप उस पे pressure डाल सकते हैं. प्रवीण जी पूछ रहे थे. So this is the section, but pressure डालने से अच्छा you explain to him the process during the insolvency resolution process itself. And there are other restrictions and disqualifications which arise due to the commencement of bankruptcy. जो बाहर से तो बहुत अच्छा सा दिख रहा है लोगों को, and people are being advised to file their own bankruptcy, but it is not similar to the one which is happening in US or other countries. And in India, it will always be seen as some, it will always bring a bad repute, and your social standing will definitely be affected. So for any false information or concealment of information by the bankrupt, if knowingly he conceals or omits or wrongly represents any information, then an imprisonment up to 6 months and fine up to 5 lakh or both. This includes non-disclosure of details of disposal of any property which would have been part of the BT estate. If fraudulently withheld or destroyed or falsified or altered the books or records, then imprisonment up to 1 year or 5 lakh or both. If contravened the restriction or disqualifications under section 140 or 141, then up to 6 months imprisonment or 5 lakh fine or both. If not delivered the property under control to the BT, up to 6 months imprisonment or 5 lakh or both. If 12 months before filing made substantial loss, then up to 2 years imprisonment and 3 times of the loss or 5 lakh of value or both. Any wrong actions by the BT, quite a wide section. Imprisonment up to 3 years or fine up to 3 times of the likely loss or 5 lakh or both. There are certain other regulations also which do not have their counter in the section. So this is important, that realization of any security interest has entire process which is there in the section 52, but it is not there in the IPC. So it is only covered by the regulation 31, which provides in detail about the process of realization of security interest by any creditor, which is quite similar to the liquidation one. Then regulation 32 talks about the bank account. BT shall open an account in the name of bankrupt, followed by the words in bankruptcy process in a scheduled bank for the receipt of all monies that shall be due to the bankrupt. Now tell me one thing, what shall we do with this account once this account is opened? Shall be in the name of a person. So it will necessarily be an individual account, and it will not be a saving account. And you will transfer all the incomes, you will route them to this account hereafter when the account shall be opened. And thereafter, all the realizations from the sale of assets, etc. shall take place towards this account. And then you will allow some expenses to be incurred by the bankrupt from this account only. Under the bankruptcy process for personal guarantor to the CD regulations, there are certain forms which include Form A, which is a consent to act as BT, Form B, which is form to appoint a proxy. There is Schedule 1, which talks about the fees of bankruptcy trustee, and Schedule 2 is the mode of sale, which is quite similar to the liquidation regulations. There are certain forms under the IBBI application to the adjudicating authority for bankruptcy process for personal guarantor to corporate debtor rules. Form A talks about the application by guarantor to initiate the bankruptcy process. Form B is the application by creditor to initiate the bankruptcy process. Form C is a public notice to be published by AA or the BT. Form D is a notice to the creditor to file their claims. Form E is a statement of financial position of the bankrupt. Form F is a claim with proof by a creditor. And that's it. I have to now add certain cases which have been admitted and the BTs have been appointed. There are many of them, but they are not readily available. So I'll just add them to the presentation and then share this presentation with ICSI, and they will then share it with you. So any person amongst you who has been appointed as a BT? Nobody? In one of the matters, I have been closely assisting one of my partners in the bankruptcy matter. Therefore, I got to know about the practical challenges, and therefore, I was keen in taking this subject with you all. So, I do have some practical, knowledge of some practical difficulties which I am facing. If any of you would like to share his or her experience, even if you are handling any individual insolvency matters, the problems must be similar because
Harmeet ji, please share your experience.
Yes, that is what I have written in the entire presentation. Challenges start from the day one. I got some information from the individual insolvency time period. Therefore, that information was quite helpful. But the bankrupt has not disclosed all the assets. He has already sold some of the assets, which I am finding relevant sections wherein I can just add them to the list of, PUFE ones. But problem is that transaction auditor appointment is not clearly stated. We have again apply our minds. Valuer is not clearly stated, so I have to apply my mind here. So there are actual real problems because arising out of the poor drafting of the law and the regulations, because nobody has paid attention from the lawmaker, nobody has paid attention to this chapter. Let me say that. And they must have thought that जब ही होगा practically, जब ही तब देख लेंगे. अभी initial pages को correct करते हैं. And there are a lot of drafting issues. No problem. We know the logic. We know we understand where they come from and what do they actually wish to include and what do they wish to achieve from bankruptcy process. But this is a case of an individual. So assets have to be handled in such manner. Valuations have to be assigned in such manner. Possession has to be taken in such manner. It is not a company that you just go and inform the authorities and employees that you are, in charge of the affairs of the company. It is not a regular CIRP something. So how and up to what extent you will send intimations to which authority, to which all companies, some companies he has disclosed, some companies I have found out on MCA, but where he has resigned and private limited companies are there. So I don't know where he has been a promoter. It's not a listed company that being a promoter is easily traceable. So there are many areas where individual information is not available. And you are not able to take possession of and actually hold the business and hold the activities of the bankrupt into your control.
So in such case, have you taken have you filed any application to A for taking the order against the bankrupt?
No, because till now he is cooperating and whatever information he is submitting, he's submitting. It is our understanding that the information may not be complete.
How much stake is involved?
See, the company for which he has been a guarantor is 700 crore debt.
My God.
Because that is a CD. All CDs have that much of debt. And whatever offer he had at the time of insolvency, he offered 5 CR. So bankers took it to the bankruptcy because 5 CR was not acceptable against 700 CR. And repayment plan was not approved.
So repayment, how much time it consumed in preparing the repayment plan and approval or rejection of repayment plan?
See, individual insolvency took nearly 2.5 years and it got admitted very recently in the bankruptcy process, yes.
So against 6 months, it took 2.5 years.
Yes. So that is what is happening in all the cases across, no?
Oh, good.
I am aware of one voluntary liquidation process which is stuck in the NCLT because the application was filed during COVID times. So it is pending for 5 years now. In today's date, a voluntary liquidation has to be completed within 3 months,
Principal bench.
Let me not comment. Practically, though, we are all aware of all sorts of problems we face, but bankruptcy is something really new because you're dealing with the assets of a person, very, very personal assets. Jagdish, you would like to contribute something?
Ma'am, I wanted to ask you one question.
Hanji.
I am also appointed as personal guarantor in one of the cases.
Personal guarantor?
Personal guarantor to corporate debtor. Not
Yes.
personal, means RP to personal guarantor. Means
Okay.
I'm not a personal guarantor.
Yeah.
So no, I
So-
wanted to know because now NCLT appointed me
Yeah.
because I was on the panel,
Mhm.
IBBI panel list of
Mhm.
RPs.
Mhm.
But no, NCLT approved fees of rupees 2 lakhs. Now I have filed my report also, but I don't know, means expenses are only advocate expenses. Advocate has helped me a lot in that case.
Mhm.
So I don't know how to raise final bill and what should be the amount. Ideally, what is the fees in this case which we normally charge?
See, there is no fees fixed in the insolvency resolution process of PG. Fees is also not fixed in the bankruptcy process. It is only where the COC does not decide, then you go by regulation 4.2. That has a schedule and you have a certain percentage to apply. But if you are talking about individual insolvency resolution, and there is no fees fixed. If NCLT has fixed your remuneration as 2 lakh per month, so that is something you must take. Thereafter, whatever expenses have been incurred in the conduct of that process. And in case the COC has approved them, then you have all right to, recover them from the COC itself. Not recover them, they need to reimburse.
Correct. No, it is not. It is not per month 2 lakh rupees. It is lump advance 2 lakh rupees
Achha,
before filing of
advance.
the report. I filed my report.
Okay.
I filed
so
my
you,
report.
Okay. So in that case, you must get your fees fixed at the COC meeting and get it approved. Thereafter, start taking that monthly fees or in whatever manner they are approving that, or whichever is comfortable to
I
you.
think COC will come into picture only after admission.
Only after admission. That's my.
Thereafter, you will get the fees. And
So
now
initial expenses, so you are taking that 2 lakh is taking care of that initial expense. No?
So unless we raise bill, they will not pay us, na? So we will have to raise the bill also for that.
Yes, definitely.
Ma'am, and second question is with respect to appointment as bankruptcy trustee. Now, is there any mandatory provision whereby the RP who is acting as RP in the personal guarantor matter should be appointed as bankruptcy trustee, or is that an option given to the RP?
The law is silent. There is no IBBI circular to this in this respect.
Okay.
So let us see what NCLT thinks about us.
Okay. All right. And is this area a lucrative area for practitioners?
I
Insolvency?
can't say right now. No assignment is bad, I must say, because
I know.
some people don't have assignments only.
Because now
We must-
CIRP assignments are very few only assignments are
Yes.
coming.
So no work is bad. But at the same time, there are challenges which have not yet been settled. The
Correct.
process is very new. Only 3-4 BTs I have seen till now who are actively working on their matters. Others are still finding it difficult to understand how to proceed, what to do, because promoter अपने गाने गाता है, वो उनको घुमा देता है. RP बेचारा एक professional ही है ना, बेचारा अगर मैं बोलूँ तो. As a professional, how much and till what extent, up to what extent you wish to help him in taking benefit out of this law, getting himself discharged, and working in the direction in which the law was actually made, is actually made. So it is actually to be seen in all the matters separately.
And personal guarantor, sorry ma'am, the personal guarantors also understand our position. They understand that we are professionals. So many times they do not cooperate, but no, they know that we have limitations.
Yes.
And we have to abide by law and do all such things which may not be looking good.
Among us, we can say Bichara. Otherwise, in the eyes of IPVI, we are Sahansa.
I तो find the professionals बेचारा only because उनको सब तरफ से accountability सब तरफ की है और उसको सबको आंसर करना है, उसको सबको सारे stakeholders का interest भी maximize करना है.
So true.
अपनी फीस के लिए वो बेचारा ये फोरम में आके क्वेश्चन पूछता है. आप ये देखो ना उसकी फीस कहाँ से बनेगी? Not clearly written.
See, our fees is actually the last priority for us because we always think that we should do all projects.
Compliances first.
Compliances.
I think we should do all the हम compliances के बारे में सोचते हैं दिन रात को भी याद आ रहा होता है कोई फॉर्म तो नहीं छूट गया.
कुछ गलत नहीं होना चाहिए, बस हम यही सोचते रहते हैं. फीस तो हमारे ध्यान में नहीं रहती है.
सही
नहीं,
बात
उसके बाद फॉर्म के अलावा फिर अमेंडमेंट कहीं रात को अमेंडमेंट तो नहीं कुछ हो गया, ये भी देखना।
वो तो मिल ही जाते हैं, सुबह सारे ग्रुप्स पे आने लगते हैं वो तो. That is the benefit of the community you have.
Correct.
Any other experience anybody wishes to share from individual insolvency? I'm very keen to hear what all individual guarantors, how they behave, how they pose as a director, as a promoter in case of a CD. At least they don't have their personal assets on stake, right? Here तो सब कुछ उनका घर वर सब अब आपके हवाले है. तो how do they react? It's so difficult to pass through such moments. For some, it may be having emotional value, like you rightly said, Ajay sir rightly said. It is really difficult task for the IP also. Anyone else would like to share something? Because I have taken care of the entire law on the subject. And most of the practical difficulties which I faced, which I could think of, I have listed them in the presentation itself. So if you have anything else to share, else we can close the session.
Okay, thank you, Harmeet ji. It was very nice session, very interactive session.
Thank you, Ajay. And if I request everyone to just switch on your cameras for once, I need to take a picture and smile, please.
Thank you so much, ma'am. It was really a very educative session for all of
Thank
us.
you. Thank you.
Thank you. Thank you.
Thank you,
Thank you so
ma'am.
much.
Thank you very much.
Thank you, sir.
It was a wonderful session, ma'am.
Thank you. Thank you.
Thank you. Thank you so much.
Thank you very much, ma'am, for such a wonderful session, for sharing your knowledge in the bankruptcy process. Ma'am, you are requested to share a PPT.
I will. I'll just add the cases that have been admitted over the past few months, because since January only I've seen cases being admitted. After November, there was a silence, there was a vacuum, and people understood what the court has said. And in January, cases started admitting. So there are many of them. I'll just list them down. Put their numbers also, so that if you wish to look at them.
Sure.
Thank you very much.
Right. Thank you. Thank
Is
you
it
so
done
much,
for the day?
everyone. Sorry.
It's done. It is over for the day.
Yeah, Anjali will tell.
Yes.
Yes,
हमने
sir, that's
हम
all for today.
या
Thank
हमने
you,
तो
ma'am.
लॉ पढ़ लिया है पूरा अंजलि.
Thank you. Thank you.
Thank you so much.
Ma'am, if you have more cases, then if you want, you can discuss.
I will have to list them down because I just read them through. All the orders were similar, so I didn't find much in the bankruptcy admission orders. So I didn't take them in the presentation. I was concentrating on the law only because अभी तक cases हुए ही नहीं है. And the questions of law have not been put before various forums. So अभी तक तो सिर्फ admissions हुए हैं. So admission के orders I will list in the presentation and send it to you. ठीक है जी. Thank you.
Thank you, ma'am.
Thank you,
you so much.
everyone.
Okay, thank you.
Thank you.